Good morning, members of the public and council members. So we will be beginning our day with public testimony on C1, crab arbitration. Before we do, I just make some brief announcements. I'd like to announce on the record that the council has selected 2 additional recipients of the Bob Mace Distinguished Service Award, which I presented to 2 recipients last night at the council reception. So one was Bill Twite, who was recognized for his exceptional 20 years of service to the council, including vice chair and chair of the council committees, both at the council and national and international scientific and management meetings. Bill always championed the sustainable management of the North Pacific fisheries, and we recognize him for his remarkable dedication, leadership, and enduring contributions to fisheries management. And Dave Witherall is recognized for his 33-year career with the council, during which he shaped nearly every facet of the region's fisheries management, as well as providing steady and thoughtful leadership as deputy and executive director. David also contributed significantly to the scientific community through peer-reviewed articles and public information materials. He leaves an enduring legacy of scientific rigor, collaborative problem solving, and unwavering dedication to the stewardship of North Pacific fisheries. So we appreciated the opportunity to recognize these 2 individuals yesterday, and appreciated staff's all the work that council staff put into organizing a really special event last night. Also, for your awareness, at 3 p.m. today, we have an executive session scheduled, so we'll be breaking for the day at that time. It may happen a little bit earlier or later, depending on where we're at with our agenda, but we'll try to shoot for that scheduled time at 3. And the SSC will not be giving its report until 8 a.m. tomorrow morning. So with that, I think we're ready to begin public testimony. As a reminder, individuals and companies will have 3 minutes to testify, organizations and associations 6 minutes. We have 9 people signed up, beginning with John Iani. I think he's joining us remotely, followed by Daniel Foe.
Hey, good morning, Madam Chair. Can you hear me okay?
Yes, good morning.
Yeah, thank you. Good morning, members of the council. My name is John Iani. I'm testifying on behalf of the North Pacific Crab Association. I'm testifying on agenda item C1, crab arbitration. We support the AP motion for the changes, the minor changes to the binding arbitration, crab arbitration system that was contained in their motion. And I'd like to discuss a couple of those in more in general, but we do support the changes passed by the AP. The binding arbitration regulations are very, very tight and very specific when they were passed 20 years ago, when the crab fishery was an open access fishery, and binding arbitration was put into place as a last resort. In other words, it was a protection for harvesters in the case of a bad acting processing quota shareholder, because there had never been processing quota shares in any fishery before, and there hasn't been since. So the binding arbitration system was designed to provide the harvesters with a protection if they needed it in performance of the crab operation, either through delivery terms, price negotiations, or other issues. In fact, even the non-binding price formula is called non-binding. So it was meant to be a protection. It has now become a tool of the fishery used by the harvesting side, that arbitration is always there, and IPQ holders realize that. So the binding arbitration protects a price system where the harvester and processors are supposed to have a traditional share of the first wholesale value. That was what it was before the program went into place in 2005. So it's 20 years old, and the data that it was based on is even older than that. It's significant, and the reason why we're asking for these slight changes is the crab fishery has changed dramatically. We're 20 years later. We have IPQ holders, processing quota shareholders, who don't process crab or are unable to process crab, but hold PQS so that they can protect the crab-dependent communities that they live and operate in. but they must find a processing platform to process their quota share. That wasn't in place when binding arbitration went into place. We are at historical lows for the crab resource. Yes, there is some hope that their crab stocks are returning, but they're nowhere near where they were, particularly in Opelio at the time the program was put into place. And finally, on the IFQ side, the majority, as the document points out, the majority of IFQ, crab IFQ, is leased. It's leased out to active participants, and the leaseholders take, according to the document in the analysis, anywhere from 50 to 70% of the first wholesale value. So that traditional share that was designed in the binding arbitration system 20 years ago is now returned to participants who do not actively participate in the fishery at all. So those changes are major and require a different look. We've asked for the LBO style to be changed to allow for a contract arbitrator to select a remedy that's not one or the other, all or nothing. It adds a little bit of flexibility to an arbitration program and allows for IPQ holders who are now different in the way that they operate. As I pointed out, some don't have processing, some do have processing, to raise their concerns in a proceeding and potentially have a contract arbitrator choose a remedy that is, it could still be either or, but it could also be somewhere in the middle. The document says that the arbitrations could become longer or more costly. That is possibly true, but you will have a better decision, arguably, if the contract arbitrator can roll up his or her sleeves and really decide what he or she thinks is best based on the evidence provided in front of him. And it may not be the exact proposal brought by one side or the other. It is hard for me to understand why adding flexibility and allowing for a contract arbitrator to have a range of potential solutions is either unfair or inefficient. It seems to me that it adds a little bit of flexibility that would be able to help in an arbitration. With regard to the writing, we have always wanted to have a better understanding why a contract arbitrator renders a decision. I think anybody in the room would want to know why a decider made the decision that they did in a transaction that they're involved in. We understand the antitrust concerns raised by NIMS, and we certainly don't want to cross those lines. Everybody here understands the antitrust laws, but understanding the rationale why a arbitration decision was made will further educate each party to the proceeding and provide for a feeling like it was a fairer and more flexible proceeding. We do think that a more orderly procedure to withdrawing IFQ or IPQ applications is particularly important in light of the small crab tax and in light of the very squeezed schedule between when tax are issued and share matching has to occur. It'll provide for some flexibility in these years of very, very low crab quotas. Thank you, Madam Chair, and members of the council. I'll be happy to answer questions.
Thank you very much for your testimony. We'll see if there are any questions for Mr. Iani. Yes, Ms. Goen.
Thank you, Madam Chair. Ooh, I got to wake my voice up. Thanks for your testimony, Mr. Iani. I have a question on how changing the arbitration style is going to help change the ownership of processor quota into the hands of those that have facilities. How is it going to help address the lack of shore-based active processing facilities?
Thank you. Thank you, Madam, through the chair. Thank you, Ms. Goen, for the question. That's not what I was saying. What I was saying was that if an IPQ holder who does not have processing capacity or is unable to process is taken to arbitration, its argument in an arbitration is going to be different potentially than a processing quota share holder who does have processing and has an argument with the IFQ holder about another aspect. It would allow, instead of, so for example, ICE arbitrates on behalf of all the IFQ holders. So ICE goes into an arbitration and says, we want X because we always get X, or that's what, somebody is doing, so we've got X. It would allow a different IPQ holder with a different set of circumstances to argue for Y or Y prime in an arbitration. So it would provide for, and the arbitrator would not be bound by having to choose only one or the other's proposal. That's the point, is because the crab fishery has changed so dramatically since the program went into place, and the way the participants are operating so differently now, we think that the arbitration proceeding ought to allow for flexibility and ought to allow for a contract arbitrator to make a decision that might be different from what the parties represent. Of course, it wouldn't change the regulation. It wouldn't change arbitration at all in terms of the contract arbitrator could still choose one or the other side's proposal, but it would provide more flexibility.
If I could follow up, thank you for that. And I understand the added flexibility. I guess what I didn't hear in your answer was how it's going to address the lack of processors that are active.
Through the chair, Ms. Goen, that's not what the problem statement was designed on this particular issue. It was adding more processing capacity is a different problem that is not one that I don't think is addressed by the crab rationalization regulations, at least not any that I've read. This was a problem statement that said that the binding arbitration, the crab arbitration program's rigidity or flexibility is damaging participants on the processing side. And that's what we're hoping to address with this proposed minor change to the way a contract arbitrator can make a decision.
Thank you. Are there any other questions? Yes, Ms. Baker.
Thank you, Madam Chair. Thank you, Mr. Iani, for your testimony. I have a question about the portion of your testimony about, let's see, alternative to option 2, what the council is considering in terms of recommending that a report from the arbitrator be required and provided to both parties. I think you can provide some good context to the information that's available to us in the analysis, which on this particular issue, essentially warned us that any report would obviously need to exclude information that violated antitrust laws, and got into some more detail about that. But also, so I'm wondering, from your perspective, the analysis says that the information included in the report, particularly the rationale for the arbitration decision, may need to be so generalized that it may not be that useful. Can you please provide, what you think might be able to be provided in that report that could be useful rather than excluded and trigger by antitrust concerns, please?
Thank you, Madam Chair. Thank you, Ms. Baker, for the question. I think that, and I certainly understand the concerns raised about antitrust. There are prohibitions on competitors sharing information that is anti-competitive or could resolve in an anti-competitive result. Antitrust law, I'm not an antitrust lawyer, and antitrust law has changed in the 20 years since the program went into place. That the Supreme Court is concerned about, and the Department of Justice are about anti-competitive impacts, and that has been changed over time. I think what we're really asking for, and is to just have an understanding. The current status is that an arbitrator makes a decision and does not need to explain that decision to the parties, and that I think is insufficient, in that the parties ought to have at least an understanding from the contract arbitrator as to why the decision was made. And I think that can be done in very general terms without sharing information. Certainly in an arbitration proceeding, information is brought before the parties I presume I've never been in one, and I don't have any information about how they've actually been done. So there's information shared during the meeting. Both sides present their arguments and their backup or their rationale for their arguments. What's missing, I think, is a better understanding from the contract arbitrator when a decision is rendered as to why that decision was made. And I think that's what we're asking for, is some clarification, albeit without violating antitrust, some clarification to the parties, before they depart, as to why a decision was made. And I think that's important now because we do have these situations. So, for example, in option 4, this non-performance, if it's LBO and you have an IPQ holder that cannot process for whatever reason, whether they don't have processing capacity or the economics of operating in the Bering Sea are so high that they can't operate, if they go to an arbitration, the arbitrator will have to make a decision under LBO. It'll have to choose one or the other. And it would be, I think, a tragedy if that decision was made adverse to somebody who had no understanding as to why it was made. And so that's the problem, I think, with the rigidity of the LBO system. And it would be helpful, I think, for a contract arbitrator to provide some description or explanation of why the decision was made.
Thank you. Are there any further questions? Okay. Seeing none, thank you for your testimony.
Thank you.
Daniel Foe is next, followed by Craig Lowenberg.
Good morning, Madam Chair, councilors. Joined by Jake Jacobson this morning, and he may field some questions if that's all right as well, in addition to myself. My name is Daniel Foe. I am counsel for the Intercooperative Exchange, which is comprised of 157 holders, unaffiliated catcher vessel owners, CVO, CVC, CPO, and CPC quota shares. So the vast majority of harvester quota that is held. ICE supports only Alternative 2, Option 3 removal of the market report at this time. The crab rationalization programs worked effectively for 20 years. It ensures a fair balance of this shared resource amongst harvesters and processors. With respect to my comments, I'm going to focus primarily on the preferred alternatives, but I'm happy to field questions on any of the others. With respect to Alternative 2, Option 1, abandoning LBO arbitration, ICE is opposed. LBO arbitration is streamlined, efficient, and effective. It disincentivizes engaging in arbitration because it disincentivizes taking extreme positions. As an attorney counseling my clients, and a hypothetical client, if there's a last best offer arbitration, I'm going to have a wholesale different assessment of the involved risks as compared to a standard commercial arbitration. Because in a standard commercial arbitration, you have very little risk of the adoption of your adverse party's position in whole. Whereas in LBO arbitration, that is your risk. That is your sole risk. So you are much more likely to roll the dice on a non-LBO arbitration because you are more likely to receive a decision that lies somewhere in the gulf between the opening positions or the last best offers. The analysis notes some additional considerations from that were presented in June, and I think they are valid with respect to retaining the LBO system. It was noted that it will likely result from moving away from the historical division of wholesale prices to consider costs. Well, that was not the system that the harvesters agreed to at the outset of this program. That was an essential component of the system, was to not include costs as a part of the consideration, but just the distribution of revenues. So we are moving away from the understanding that was in place at the time the system was created. It's been acknowledged by the processing sector that costs will likely increase. And there's logical reasons for that. If an arbitrator has to write an informed decision and present it to the parties and has to hear more evidence as to supporting one price versus the other, they're going to take more time. There's going to be more lawyers involved. They're going to probably hire expert witnesses to justify the costs. It's just going to be more expensive, and that's acknowledged. With that in mind, I think it's important that we consider the stated purposes for this action. One, to reduce costs, which it's acknowledged this act, removing LBO will increase costs. And two, to address low tax. Well, biomass is increasing, taxes are increasing. So we've kind of lost the forest for the trees, I guess. We're going to increase costs, and we're proposing permanent changes to a system to address an issue that has proven, at least at this time, to be fleeting in nature. So I think that making such a fundamental change that is not supported by, the purpose of this whole analysis is a bad thing to do. Another aspect of the removal of LBO would be that the regulations provide that costs are split. So the party with more resources is more likely to spend more on arbitration and in my experience as an attorney, the party with more resources has a higher probability of winning. It'll disadvantage the party with less resources, and that's the harvesters. With respect to the written decision, none of our contract arbitrators are lawyers who specialize in antitrust. If I am presented with a matter as a lawyer, I have a rule of competence that I cannot prepare a decision or I cannot issue an opinion in an area of law that I'm not competent to practice in. So if I'm the contract arbitrator and I am presented with an arbitration requirement that I issue a written report that has antitrust concerns, I'm either going to decline it, I'm not going to take the arbitration, or I'm going to make it a requirement that I retain the services of an antitrust attorney and pass it through to the parties. Antitrust attorneys aren't cheap. They go for thousands of dollars an hour. This is not something I think the parties want. With respect to alternative 3, the withdrawal of IPQ, I think that a very good point was raised. What happens if everybody withdraws their applications? While ICE recognizes this is something that occurs and regulating it is better than having it occur just kind of on a case-by-case basis, we're putting the cart before the horse by not putting in place regulations to address that issue at the same time or before we put in place regulations that allow the removal of the IPQ applications. So what may be better suited for a future action rather than something we do today with this not yet being fully analyzed for that scenario. With that, I think it's important to note that in entering into this system, the harvesters gave up their right to sell their crab to the highest bidder, whereas the processors can still sell their processed crab on the open market. So we are removing protections for harvesters that they received in exchange for removing their ability to sell to the highest bidder, and it's unfair to take those protections away.
Thank you very much for your testimony. See if there are any questions. Yes, Ms. Goen.
Thank you, Madam Chair, and thank you, Mr. Foe, Mr. Jacobson, for the testimony. I'm wondering if you can speak a bit more to, which one was it I was wondering? The alternative 2, option 4, I see in your, this is on the non-performance arbitration. I see in your comment letter that ICE says that they don't support that option, but I'm wondering if you can speak to how keeping non-performance arbitration has benefits for harvesters and how it impacts processors, but focus on harvesters.
Right. Through the chair, Ms. Goen, thank you for your question. ICE is fundamentally opposed to the removal of arbitration for performance disputes. It is an incredibly important tool, though it has not had to be utilized to prevent a processor from essentially breaching their contract with the harvester. To rely on the civil courts would take more time and would be more expensive and would have uncertain outcomes. Mr. Iani, I believe I heard him mention that LBO applied in performance arbitrations. It doesn't. These are traditional arbitrations. So if you're looking at the context of this occurring in a lawsuit, a lot of these boats are based in King County, Washington. This case schedule is a year out. So what good does that do you if your crab is not getting processed and your resolution is a year out? And the reason for arbitration is for a fast resolution of the dispute. And that's what is needed in a, we see the timelines in these fisheries. They're fast. You need prompt decisions.
And a second question, this one's on alternative 3, and I appreciate that you mentioned that the council might consider a stepwise fashion if they're considering this alternative, but I didn't hear you speak really to the lengthy season agreement, which I see in your comment letter. I'm wondering if you can explain a little bit more about the importance of that tie with the lengthy season agreement.
Right. So a lengthy season, in fact, Jake maybe have some input on this one as well, through the chair, Ms. Goen. The lengthy season agreement has to be made before the season starts. So if you have a situation where you are withdrawing the applications for IPQ, you're going to disincentivize instead conducting a lengthy season approach. So you may have a situation where a processor panics, removes their application, whereas they could have worked it out in a lengthy season agreement otherwise. So I think entrenching or enshrining the ability to do the lengthy season approach in the system, say, hey, you should first negotiate to try to do a lengthy season before you can remove your IPQ, it would be more effective. And realistically, and we're talking about a valid concern in that IPQ holders rely on custom processing, and the cost of custom processing are too high in some cases. I think rather than eliminate or change the arbitration system as it stands, perhaps a better solution would be to add to it, to add the ability for a last best offer arbitration on custom processing fees as between IPQ holders and custom processors. That seems like a much more efficient solution. So hopefully that addressed your question.
Yes, Mr. Sugata.
Yes, thank you for your testimony. I thought you had mentioned that a strong point that I thought you made was that the harvester gave up their ability to sell to the highest bidder, but the plants can sell their product to the highest bidder. And I thought that was a fairly strong argument. But having said that, I think back to a previous testifier that was saying that most of the IFQ is leased. And if you're not leasing it, I guess my assumption is that you're making more than you would make from the lease. Since the harvesters typically receive a percentage of the first wholesale value, aren't they benefiting from the ability of the processors to sell to the highest bidder? And that's not necessarily a negative for the harvesters?
Through the chair, Mr. Sukata, thank you for your question. That is what the system is designed to entrench now, is looking at the division of first wholesale revenue. But that's what's entrenched in the non-binding price formula, and that is a fundamental assumption. We start chipping away with that with the proposed actions. You're starting to bring the processor's costs into consideration in their setting the price, and we're moving away from first wholesale revenue as the basis for determining the price paid to the harvesters. So that comment was made in the context of why we need the system to maintain those protections, to maintain the ability of the harvesters to enjoy the benefit of the processors selling to the highest bidder, rather than having their price further eroded by cost concerns that the harvesters bring up in a broader arbitration.
Thank you.
Thank you. Any further questions? Seeing none, thank you for your testimony.
Thank you, Madam Chair.
Craig Lowenberg is next, followed by Shannon Carroll.
Good morning, Madam Chair, members of the council. For the record, my name is Craig Lowenberg. Excuse my voice this morning. I'm here today on behalf of KBO Crab Co-op, which is the second largest voting district or sub-co-op under the Inter-Cooperative Exchange umbrella. KBO represents approximately 70 independent harvesters that hold crab IFQ. We're very concerned about the anticipated effects of the changes to the crab wrap program being considered under this agenda item. KBO members, and I suspect most independent crab harvesters, prefer the status quo as opposed to the motion passed in the AP. Specific to alternative 2, these are not small or minor changes, but rather a fundamental change to the intended design of the crab wrap program. The arbitration program is not broken. There have only been 2 arbitrations in the past 10 years, both of which were triggered by processors paying well below the price paid by other processors. Because of the last best offer style arbitration, harvesters only asked the arbitrator for price paid by the lowest payers. Access to the arbitration system is very difficult for harvesters because of their FCMA status. ICE is the only cooperative that can arbitrate. I would note there have not been any arbitration events in recent years of low crab tax. As long as harvesters must share match with IPQ holders, the arbitration system must remain in place, especially the LBO component, as it's the only viable means by which harvesters can ensure they're paid a fair price for their catch. Harvesters' agreement to the development of the crab wrap program, which necessarily caused them to give up the right to sell their crab to the processor offering the highest price, was based on the maintenance of the historical division of revenues between harvesters and processors being enshrined in the crab wrap program. The changes proposed to the arbitration system will undermine this bargain, and the council should exercise restraint rather than make sweeping changes to address issues that have proven to be fleeting in nature. I would also note the process is not one-sided. Both harvesters and processors have won arbitration events. Specific to option 1, last best offer, LBO arbitration is fundamental element of the program. It was implemented to maintain the balance of power between harvesters and processors due to the issuance of IPQ and the requirement to share match. The risk of losing is a powerful disincentive to arbitrate that would effectively be removed if the arbitrator can choose a compromised price. It's reasonable to assume that without LBO arbitration, there will be significant increase in arbitration events and therefore increased costs. Mr. Brennan referenced this in his presentation. In his conversation with arbitrators, they expressed the reasonable assumption of increased cost of arbitrations due to the fact that they're paid by the hour, not by the event. Also, that the current structure drives participants to provide a reasonable offer at the onset of the arbitration. In specific to option 2, the written explanation of the arbitration outcome, arbitration issues aren't that complicated. If a processor offers a price that's well below what others pay, they may end up in arbitration. Written report and rationale will increase the cost of the arbitration program. I'm not an attorney or claim to be an expert in antitrust issues, but I am an FCMA qualified fisherman, so I have a basic understanding of the boundaries. And it seems to me that a written explanation of arbitration outcome treads dangerously close to antitrust territory. Specific to alternative 3, I'd point out at the last meeting on this agenda item, there was a lack of consensus among processors during public testimony. It was noted that withdrawal of IPQ and IFQ applications could be used as a negotiation tactic. Even with clearly defined rules, harvesters fear that this change could be a slippery slope as it stands. Harvesters and processors will often enter a lengthy season agreement, which you guys just heard a little bit about. It's a basic assumption of the crab wrap program that holders of IPQ are supposed to actually process the crab, and both harvesters and processors run the risk of that a particular season may be unprofitable. The council should consider that if IPQ holders can unconditionally withdraw applications, how are harvesters supposed to be protected? So any new rule must preserve the right to do lengthy season and the right to arbitrate. In the design of the program, one extremely significant concession that harvesters made was their access to free markets. That's exactly why LBO and performance arbitration were put in place. I believe harvesters are limited to 1 arbitration per processor per year. This is why we enter into the lengthy season agreement prior to the start of the season. If we enter into a lengthy season agreement and processors withdraw their IPQ, harvesters are at a further disadvantage in the market. There may not even be a market available at all if all the IPQ is withdrawn. And I've heard many say that this won't happen, but it's definitely not a zero chance, especially with only two processing plants currently. In reference to the purpose and need, the purpose and need statement details that the changes being considered arose out of concerns regarding high annual uncertainty, fishing closures, and low tax. And since this action was initiated, biomass has rebounded and fisheries have reopened, tax have increased. I recognize we're not at the level we were when the crab wrap program was put in place, but the trends indicating a high probability of continued improvement, and it seems inappropriate to make significant sweeping changes to address temporary conditions. With limited resources and budget, I question whether this action is even worthy of council consideration at this time. Again, the proposed changes will not reduce costs, but rather increase them and cause disruptive changes to the program and cause additional uncertainty. It looks to me that the effects of this action would essentially further shift the financial burden of processor consolidation and custom processing fees onto independent harvesters. So we urge you to take no further action on this agenda item. Thank you, Madam Chair.
Thank you for your testimony, Mr. Lowenberg. I'll see if there are any questions. Yes, Ms. Kimball.
Thank you, Mr. Lowenberg, for your testimony. I guess I just have two questions. I mean, the formula that you reference as being so critical is not going away under any of these alternatives. The arbitration system's not going away. There's still a powerful disincentive to arbitrate. And so I'm curious why you would think a processor that comes in well below, I'm trying to follow your testimony, well below the going price would succeed in an arbitration, given that the price formula is still there and all the other factors that the arbitrator is currently allowed to consider are also available. So that's what I'm trying to understand with this change, why you would think that somebody would succeed if they came in well below market price.
Thank you for the question, Ms. Kimball, through the chair. If I understand your question correctly, I'll do my best to answer this. If we allow an arbitrator to pick a compromise position between the two offers, then it would be most likely that you would come in with a lower offer than you would have otherwise as your last best offer in the last best offer situation, most likely, right? Because you would assume that start low to end up somewhere in the middle where you might want to be, right? So I see the two parties going further apart, and I would expect to see significantly lower offers going forward. I hope that answers your question. I'm not sure I did.
It does. I asked for your opinion. So even if we disagree, I appreciate your opinion. My second question, people keep referencing the purpose and need, which it is not just about low tax. I see in the purpose and need, it also talks about the challenging cost structure associated with processing right now. And so one of my questions is on your opposition to alternative 3. And when I read that, it really looks like just status quo, except we've outlined what the process is for people to withdraw quota. It's not forcing people to withdraw quota. It's not providing more incentive for people to withdraw quota. It's just telling people what the rules are. So I'm curious about kind of the strong opposition to laying out the process for people.
Thank you for the question, Ms. Kimball, through the chair. My concern with withdrawing IPQ at the late date is the timing of the fishery and the further disadvantage it puts the harvesters in the market condition where they have further reduced markets that they're able to access.
Thank you. Any further questions? Thank you for your testimony.
Thank you.
So Shannon Carroll is up next, followed by Julie Decker.
Good morning, Shannon Carroll. Testifying on behalf of Trident Seafoods this morning. To start, we support the AP motion. We also support the comments and testimony by MPCA and PSPA. I'm going to focus my testimony on alternative 2 options 1 and 2, but happy to answer questions on anything in our letter or in the AP motion. I want to talk about what option 1 under alternative 2 doesn't do. And that is that it doesn't change what the arbitrator can consider during arbitration. It only provides the arbitrator with more latitude to use their judgment and professional experience to make a decision that is beyond the 2 offers submitted by the processor and the harvester. And that's it. We think that allowing an arbitrator to do that, to use their own judgment and figure out what is fair, will reduce the risk of arbitration for the processors and our decision-making as we go into a season. I think it's helpful maybe to consider an analogy about the council process. I think LBO would be like there being a motion on the floor and a substitute motion, and the council could only pick 1 or 2. But in the council process, we allow motion to be amended and to be discussed and modified. And that produces a better outcome, I think. It's not as efficient, but it's more fair, and it allows you to use your judgment to craft an outcome that is balanced. It also doesn't change what you can consider. You still have to, when you're modifying that motion, still have to look at the same facts, the same analysis, and the same applicable regulations apply. And that's all we're asking for under the change to under option 1. We think it's really important. And I think why is it might be helpful to step back. It's really easy to just focus in on the arbitration program in this action, but we have to think about the broader goals of the program, and that's to maintain a healthy seafood sector that includes communities, processors, and harvesters, not just looking at this under the lens of efficiency. The program design requires that we have a mechanism to resolve price disputes. That mechanism is not working as intended, and that's evidenced by the fact that processors are not utilizing the arbitration process. Testifier noted that there's only been 2 arbitration processes in the past 10, 15 years, and that's because processors know what the result's going to be. And then the fact that processors are modifying their businesses to either not process or change their business practices to basically contract out of arbitration risk. Those things, I think, are indicative of a process that's not working, and it's a process that we have to have under the program. This process is for at least from my company's perspective, a big factor in our decision to whether or not we apply for quota and whether or not we put investments into our plants and whether or not we open plants. There's not a conversation that we have about crab processing that doesn't include the risk of arbitration. So to conclude on option 1, I'm sorry, I blew through my time there, but I would just say that allowing for the potential for an optimal decision that includes more than just the offers submitted by the parties is in our view, an effort to reduce that risk. I'm out of time, so I'll conclude. Thanks.
Thank you for your testimony. We'll see if there are any questions. Yes, Ms. Cohen.
Thank you, Madam Chair, and thank you, Mr. Carroll, for your testimony. And I appreciate your council motion analogy. I think that's a good one to help us think through this. I think I heard under Mr. Iani's testimony that moving away from last best offer would allow some movement away from the formula as we've been using it, because it allows parties to start including costs in the formula. Did I mishear that, or am I misunderstanding what would happen under option 1?
I can't speak for Mr. Iani through the chair, Ms. Cohen, but my understanding is that the only change to the arbitration process would be that the arbitrator can select an option that would be different than the 2 options submitted by both parties. That's it. They still can consider all the same factors. They just can select a different outcome. I think there was discussion in Mr. Iani's conversation and elsewhere about is that going to change the incentives for what those 2 offers would be or how the parties approach arbitration. But I think if you've read my comment letter, that's really based on theory and not backed by data, that the parties are going to come forward with some sort of gaming of the system to try to split the baby, as the analysts described it. Nothing under, if you removed last best offer, would prevent the arbitrator from choosing the harvester or the processor's proposal if it's well justified. It just allows them a little bit more discretion to use their judgment, which is, why they're hired in the first place, from my opinion.
Thank you. We'll go to Mr. Williams.
Thank you, Madam Chair. Thank you, Mr. Carroll, for your testimony. Several people over the course of the last several days have indicated to me that changing the program as described in the AP motion would result in less costs than the current system. Do you agree with that statement, or how is that possible? Because I need to understand how that might be possible, changing from what we currently do. Some say it'll get more expensive, some say it'll be less. Do you agree with the less statement?
Through the chair, thank you for the question, Mr. Williams. I agree that in the AP conversation, Daryl described there being some increased costs if you remove LBO style arbitration. I also tend to agree that with his conclusion that the cost increase wouldn't be dramatic, it would just be an increase in costs. I do also think that we've talked about this in other iterations of this analysis, that cost itself is a deterrent and can help facilitate compromise and avoidance of arbitration. I fundamentally, I don't think anybody wants to go to arbitration, but as I mentioned, under the program design, we have to have some mechanism to resolve pricing disputes. So there may be an increase in costs, there may be a deterrence and less overall costs, but my main point is that efficiency and cost shouldn't drive the decision to maintain LBO, because it's a necessary function of the program that's not working, and it's not resolving price disputes in a way that's encouraging processing activity. And I think that's why we need to make some changes to it.
Thank you. Mr. Moeller, then Ms. Kimball and Ms. Baker.
Thank you, Madam Chair. Thank you, Mr. Carroll, for your testimony. I want to make sure I understood what I thought I heard you say relative to only 2 arbitrations in the last 10 or 15 years. And I think if I heard you correctly, you said, and that's because the processors know what the outcome might be. Can you, if I heard you correctly, can you elaborate a little bit so I have a little better understanding what you meant there?
Sure. Thank you to the chair, Mr. Mueller, for the question. And this is certainly my perspective, but the track record of arbitration decisions is not favorable to processors. I think that there's been 1 or 2 instances where the processors have prevailed, but the vast majority of outcomes have favored the harvesters on the outcomes of arbitration. Given that, and given the expense of arbitration and those outcomes, it's assumed that you're just not going to prevail, and the mere threat of going to arbitration is changing how we engage in the fishery. So it's a system that isn't functioning as a fair resolution of price disputes. It's merely a pre-decisional outcome from our perspective.
Thank you. Ms. Kimball.
Thank you, Mr. Carroll, for your testimony. My question is on the piece that you mentioned but didn't get to speak to on option 2 and providing a report and rationale to the decision just to the parties. And my question really is, how relatively important is that in your perspective to this action?
Thank you. And I'm sorry that I mismanaged my time through the chair, but from my perspective, creating institutional memory for why decisions are made is really critical. I think even if the council doesn't select option one, it remains important. As I just was describing, we went through arbitration in 2021, and it was, I think, a decade before the last one that we had gone through. And there was a new arbitrator, new attorneys on both sides, and there just wasn't an understanding of the past decisions that have been made, and that really impacted sort of our decision making. I think too that there's a lot of money that rides on outcomes from arbitration, and understanding that as the report described, that the arbitrators are producing a report that documents that it's a reasoned and fair outcome based on the facts provided by the parties, and that the information was accurate and logical, I think is a bare minimum to ask of an arbitrator that's making a decision that has such a significant impact on the parties. I do recognize the antitrust concerns, and I am a firm believer that the penalties of antitrust violations are a very exceptional deterrent from engaging in any antitrust behavior. But I would imagine that there are ways to craft a regulation to accommodate the concept of creating institutional memory for parties, whether it's delaying the release of the report by a year or something like that. But I think if the intent is just so that the parties can learn and balance that risk and in the future, that there would be a way to do it.
Thank you. And Ms. Baker?
Thank you, Madam Chair. Thank you, Mr. Carroll, for your testimony. I'd like to ask a question about back to alternative to option one, to remove last best offer style arbitration. And regarding the analysis, trying to, I think did the very best that the analyst could in terms of making some assumptions and determining what the potential impacts might be. But a potential outcome may be, and we've also heard in testimony, that removing last best offer arbitration provides an incentives for substantially different offers from either party. And so do you agree that if the council moves forward with alternative to option one, that it probably would change the incentive for what the initial offers are submitted? And two, if you do you think there would be a substantial difference in those offers under what it would be under the status quo? Just trying to get a sense there.
Through the chair, thank you for the question, Ms. Baker. I don't, and I think I already covered some of it in terms of the written comment and the sort of the data showing outcomes from this LBO and non-LBO style arbitrations, and there being really nothing to support that, and based on outside of theoretical game theory that's how the parties would approach it. I also think that it's important to consider the fact that we don't a processor doesn't approach arbitration in a silo. We have relationships with fishermen that we have to maintain that extend not just to the crab fishery, but many of our fishermen tender for us. They deliver cod and other species. And so there are relationships and contexts beyond just the narrow lens of a negotiation over price. And the other thing is just that doesn't seem like a very efficient way to conduct a business as a processor. We have to offer a price that reflects the market and that we think is fair in order to survive. And so if we were to start trying to lowball offers in the anticipation of arbitration, I don't think that would be a very functional way to go about it. The other thing is as I mentioned, that there's nothing that prevents the arbitrator from selecting the proposal that is provided by the harvesters. And so the risk of coming in with an unreasonable offer, I think, doesn't set you up for, if I was an arbitrator evaluating claims and somebody came forward with something that was on its face unreasonable, I would probably judge all the evidence and data that they showed to support that with a bit of skepticism. So I think there's an incentive to try to come forward with something that's based on reason and data, so that we can convince the arbitrator that that's the proper landing place. Hopefully that answered your question.
Thank you. Any further questions? Thanks for your testimony. Next up is Julie Decker, followed by Sinclair Wilt.
Thank you for this opportunity to testify. My name is Julie Decker. I live in Wrangell, and today I'm testifying on behalf of the Pacific Seafood Processors Association. As many of you know, PSPA represents shore-based and mothership seafood processors operating 50 facilities in 22 communities across coastal Alaska and operating in almost every state and federal fishery. PSPA members include the processors that have historically participated in the Bering Sea crab fisheries in St. Paul, Kodiak, Unalaska, and Akutan. These are the companies that process Bering Sea crab and also custom processed crab for those who hold processing quota but do not have a processing facility. PSPA strongly supports the AP motion, and we've submitted some other written comments to the council as well. Our position is that these are relatively small changes in order to address the need for more stability and transparency in the program and in the arbitration process at a time when fisheries have very low tax and operational costs have increased. The fisheries are very challenging for all participants in terms of uncertainty, risk, and cost structure, which we have heard in the recent crab program review. This is very evident in the number of crab processors declining over the past decade, down to 2 in the last season. Fewer processors are participating because of the risks of operating at a loss. Last June, I presented to you a slide that documented how one of these costs, our cost of labor, has increased just in 2 years, between 2021 and 2023, increased 50%. Labor costs, and in particular costs to mobilize crews to remote areas that can only be spread across very small tacks, are big drivers of risk in these fisheries. NOAA Fisheries had produced a report about the 2023 season that documented $1.8 billion of losses across the industry in 1 year. We no longer can afford to lose money on one species and hope to make it up on other species. So I think this is a big, important part of where we are right now. I'm going to focus my comments on alternative 2, option 1, removing the LBO requirement from the binding arbitration process. PSPA is looking to allow the arbitrator to choose a compromise position if they deem appropriate. This does not remove or change the arbitration formula, but it allows the arbitrator to consider all information and use their judgment for an optimal outcome. It's really important to weigh the benefit of an optimal outcome against the potential for increased costs in the arbitration process. It's not clear that costs will necessarily increase. Arbitration itself is chosen by many businesses because it's considered a quick and efficient process for settling contract disputes, particularly when compared to the traditional court system. My personal experience with arbitration leads me to believe that no measurable differences in costs would be seen in removing the LBO requirement. But remember, we're still retaining the binding arbitration requirement. In closing, the current process is broken, as evidenced by the reduced number of participants actively processing. Why is this? It's not because processors are bad guys. It's not because harvesters are bad guys. It's because the circumstances have dramatically changed. Low tax, increased costs, thin margins across all species. These changes have shifted the risk profile to disproportionately be borne by the processing sector. I think this is a really important point. Therefore, PSPA is supporting these small changes in response to these dramatic changes in the economics of the crab fisheries. We're looking at simple ways to reduce risk that do not upend the program or substantially change the structure. We support these small changes so we can have viable Bering Sea crab fisheries for harvesters, processors, and communities because we all rely on each other. Thank you.
Thank you for your testimony, Ms. Decker. Are there any questions? Yes, Ms. Goen.
Thank you, Madam Chair, and thank you, Ms. Decker, for your testimony. And I appreciated your point at the end there about shifting the risk profile to the processors. We heard during the staff presentation that shifting the arbitration style, because there's still arbitration, so shifting the style may not change the outcomes much. It may not change the end quality of those outcomes. So can you speak to how it would shift the risk profile if we shift to this new style of arbitration?
Yes, I think as we heard the previous testifier talked about the arbitration process as is with LBO is considered weighted toward harvesters. Without the LBO, we view it will be a more fair process. I think one of the concerns about the participants starting with widely divergent positions at the beginning of the arbitration process. In my past experience, I don't think that would happen. What happens before an arbitration process is that parties are negotiating, and they're typically negotiating toward each other. You simply, when you enter the arbitration process, to avoid somebody going way far backwards all of a sudden, you just describe to the arbitrator, this has been what we've talked about. These have been the offers made to this point. And if one of the participants goes way backward, it's very obvious to the arbitrator. They're not, they're pretty smart people. So I think just the way the arbitration process is not so scary, and it will allow for a better outcome removing the LBO.
Not seeing any further questions. Thank you for your testimony.
Thank you.
So our next testifier is Sinclair Wilt, followed by Heather McCarty.
Good morning, Madam Chairman and members of the council. My name is Sinclair Wilt for the record, and I'm representing Westward Seafoods. Westward Seafoods operates 3 plants in Unalaska Dutch Harbor. 2 of these plants have crab processing capabilities with a long history of processing all crab species. For the past few years, we have only been operating 1 plant for crab processing due to the low quotas and or closed fisheries. In addition to processing our own IPQ shares, we also offer custom processing of crab for other IPQ holders. I just want to state for the record, Westward Seafood supports the following elements on agenda item C1. Under 2.2, we support option 1, option 2, option 3, and option 5. Under 2.3, we support option 2. We are aligned with the written comments submitted by PSPA and NPCA. We support the AP motion. Thank you for considering our comments.
Thank you very much for your testimony. Are there any questions? Yes, Mr. Sugano.
Yes, so thank you for your testimony, Mr. Sinclair. When you said that only one of your 2 plants that are potentially capable of processing crab is in operation, you had mentioned low quotas and closed fisheries, but I didn't hear anything about this arbitration. Can you maybe tell us the impact where you feel that this arbitration, how it impacts your guys' ability to process?
I'll do my best because I'm usually left out of those discussions. So but historically there's there's always been the fear of arbitration. It's always been the attitude under prior ownership and current wanting to avoid it because historically it has worked against processors. So I'll keep that rather general because I haven't been in specific conversations.
Thank you.
Thank you for your testimony. Next up is Heather McCarty, followed by Cory Lescher.
Madam Chair, members of the council, I'm Heather McCarty, and I'm speaking today on behalf of the Central Bering Sea Fishermen's Association, CBSFA, which is the CDQ group for St. Paul Island. We manage CDQ allocations of crab to promote social and economic development in the community of St. Paul. We've made major investments in both crab harvesting and processing quota, and we co-own and operate 2 fishing vessels. We're crabbers through our wholly owned subsidiary, St. Paul Fish Company. As you've heard, like many other CDQ groups, CBSFA does not own processing capability and depends entirely on custom processing to benefit from its IPQ investments. CBSFA is also the ECHO, the eligible crab community organization within the crab program for the community of St. Paul Island, and is thus responsible for representing St. Paul's interests in the crab management program, particularly in the process for exemption from regional delivery requirements. In December 24, the Council acknowledged that low crab tax may exacerbate the burdens of the binding arbitration system and moved to examine the functionality of the crab management program under current conditions, which may continue because of changing ocean conditions. We appreciate the additional information in the recent analysis, and CBSFA supports final Council action on the regulatory amendments to the crab management program outlined in options 1, 2, and 3, in Alternative 2, as well as Alternative 3. However, the analysis also continues to make clear that the current crab program structure has limitations and inadequacies that are not directly addressed by this action. CBSFA supports continued examination, as we have several times before, of the flexibility of the fundamental elements of the crab management program in the face of low crab availability, reduced processing capacity, and global economics. CBSFA asks that the Council initiate a discussion paper or perhaps a white paper on the emergency relief from regional delivery requirements regulatory tool, its use in the 2024-25 season and the current season, 25-26, and the effects on harvesters, processors, and communities. I'll come back to this request if I have time. Regarding the regulatory amendments, we support option 1. We support this proposed change. We see this option as linked to the issue of the suitability of the historical reference points used in developing the price formula. Conditions in the crab fisheries have changed substantially, as you heard over and over again, since the program started, and current circumstances are not adequately represented in the preparation of the price formula, so we believe that the division of rents is not reflective of reality. In CBSFA's unique position as a community representative, a harvester, and an IPQ holder, we have interest in the viability and the functionality of the crab program, and we've witnessed firsthand the impact on communities when it does not function as intended. We recognize the controversial nature of this proposed change. However, custom processing fees have basically doubled since 2016. The margins have all but evaporated for us, and we're projected to earn only a few cents per finished pound on snow crab IPQ this season. If the market drops even a little bit, we will go backwards on snow crab. As has been clear, it's difficult to know exactly how this would play out if the change is made. It might be tested, and the outcome or decision by an arbitrator could effectively begin to reset the role of the price formula, not the price formula itself, but the role that it plays in arbitration. This is perhaps not ideal for some, but without the Council being willing to undertake an analysis of how the division of rents has changed over time, this is all that IPQ holders may have to keep their heads above water. Without some change, our IPQ ownership could become a liability, and we would have to seriously consider withdrawing our IPQ in a difficult season. The analyst touched on the connection between the change to processor risk and profitability and the subsequent operational decisions and how that impacts the communities they operate in. We are seeing in St. Paul how it plays out for communities when processors make the decision not to operate for economic reasons. The impacts go beyond landing taxes, and under the current structure, it's unsettling and unstable. Regarding option 4, removing the arbitration option for non-performance, etc., under the current regulations, an IPQ holder with or without a processing platform could be taken to arbitration for non-performance by their matched IFQ holder if the IPQ holder is not able to process CRAB. Those IPQ holders without processing platforms, as you've heard from Mr. Iani, are at substantially more risk since they cannot control the decisions and actions of the IPQ holders who have processing platforms. And this is a real concern for harvesters and communities as well. Again, you've heard about that. We note that the council motion or analysis did not explicitly address the potential failure of the emergency relief from regional delivery requirements tool, which we are currently trying to use, as a possible cause of non-performance. We anticipate future issues with this limited tool, including the current differing interpretations of the regulatory exemption process. This lack of clarity and stability is affecting all 3 legs of the CRAB program stool. To go back briefly to our request for a council look at exemption from regional delivery requirements, I don't have time to get into detail here, but you can look at our written comment to see the effects it has had on our community and the people living there. We used it in the last season. It was not easy, but we made it work. And in this season, we've already had to use it on an emergency basis to make sure that Red King crab was delivered and processed in the south when it couldn't be delivered and processed in the north. And now we're facing the snow crab season with the addition of a couple of more parties to this exemption process. It's unstable. It's not a durable solution to the economic issues that we're all facing. And I think it could benefit from a council look. And perhaps you can take that up in staff tasking. Thank you very much. Happy to take questions.
Thank you for your testimony, Ms. McCarty. I'll see if there are any questions. Yes, Ms. Goen.
Thank you, Madam Chair. Thank you, Ms. McCarty, for your testimony. I think you captured most of it for the ask for a discussion paper for the tool, the emergency relief tool for regional delivery requirements. But can you speak to more of the context of what we're facing and what we need to fix and why, briefly?
Thank you, Madam Chair, Ms. Goen. Well, I guess to be a little blunt, every season could turn out to be a crapshoot as to whether crab gets delivered and processed. If one or the other region, either the north or south region, is not able to process and crab has to go to the other region. It's a complex process in itself, but when we have plant closures or plant unavailabilities, it makes it every season, it depends on the goodwill of all parties to arrive at a fair outcome. And I know people have talked about needing a durable solution, which means one that works without sort of the dependence on sort of private agreements and so forth. There's a regulatory process in place, but there's some lack of clarity about exactly how it applies to all of the players, all of the parties. It was designed to protect not just the communities, but the harvesters and the processors as well. And so it's a kind of a sign-up process where everybody has to agree to how things work. But it also is difficult because its power is limited, because nobody wants to blow up the whole crab program and say no. We all have to agree, but if we don't all agree, all the parties that are affected, then the whole program could just not work for that season. And so everybody knows that nobody wants to do that. And so it's a tough one. It's a tough one. And we need, I think, the benefit of a little bit of analysis and a closer look at the tool. I hope that answered your question.
Thank you. And Ms. Baker?
Thank you, Madam Chair. Thank you for your testimony. And I wanted to make sure I understand both your comment letter and your testimony to the what we're calling alternative to option 4, the non-performance option in terms of removing arbitration requirements for that. And so the analysis does a pretty good job of potentially laying out the challenges of moving forward with alternative to option 4. And so I'm not sure you spoke exactly to this, so I want to make sure I understand your position. If the council does not move forward with that, there's still some challenges associated with IPQ holders who do not own processing facilities. But does at least the selection of alternative to option 1 to remove the requirement for last best offer arbitration provide a little flexibility that might help?
Madam Chair, Ms. Baker, essentially, yes, we think. Again, we don't know exactly how it's going to play out if that change is made, but if we are forced into a situation of non-performance as IPQ holders, as we have talked about already, the arbitration program seems to be the first place that one should go because it's a council program. It's designed to deal with those kinds of things. So, but if it's an all or nothing answer, as the current arbitration program requires, that if it's one or the other and there's no middle ground, it's never been tested for non-performance. And so we're just not sure how it would work under the current situation. And so we do favor the option 1. That's one of the reasons we favor the change embodied in option 1. Did that answer your question? Okay.
Yes, Mr. Carlin.
Thanks, Madam Chair. Ms. McCarty, I want to go back to your request for a discussion paper on the emergency relief from regional delivery requirements tool. And I'm struggling to understand from both your comment letter and your testimony and your response to prior question, the scope of such a discussion paper. Is it the tool that you are looking to have evaluated, or is it really the regional delivery requirements themselves? What's the scope of analysis that you are seeking from the council?
Thank you, Madam Chair. Mr. Kurland, that's a good question. As you probably know, the regional delivery requirements are the main community protection aspect in this program. And they were put in place to reflect the historical delivery of crab, the historical landings. And so we believe that it's an essential part of the program that should be retained. But the challenging conditions that we now face are now, for the second time, requiring exemption from those regional delivery requirements for the North. And I know you know that. I'm explaining that to the rest of the group who may or may not have been around for that, for the development of the program. So we strongly believe that those regional delivery requirements are important for community protection, for the three-legged stool. And so what we see with the exemption process is we sort of put it together, and it was designed for, as you probably know, for sort of physical conditions that prevented landings in either the north or the south. Something blows up like it did in the red king crab season. The processing capability in the north blew up, literally, I think, and they were unable to process crab in the north. So we were able to use the exemption tool pretty handily in that situation because it was an emergency situation. NIMS was great, everybody was great. Unalaska was great, and those taxes for that north crab that was delivered south are going to be remitted to the north. But again, there's no real requirement in the tool that gives us a sense of protection and stability, because each season there's a process that's relatively laborious that takes weeks and weeks and weeks, months actually. Last year it took, from October to Christmas and through Christmas to reach those agreements that we reached. This year we're not there yet. We have, I think, 27 days to reach an agreement for the delivery of North Crab South. and we have 2 additional communities that are involved, or community sort of taxing entities, if you will. And so it's gotten more complex. And there's just a few of us sort of working all the time to try to figure out how that's going to happen. And there's no guarantee that it will. And so there's a lack of stability. There's a little bit of a lack of clarity in the regulations themselves. As you know, because we've been asking about that. And so I just think it would benefit from perhaps not a discussion paper, because we don't exactly have a problem statement worked up. I'm sort of talking about it now out loud to you guys for the first time. But we know that we are subject to uncertainty every time this happens. And if the South was in the same position, they would also be subject to that kind of uncertainty. It's not just a North region problem. It could be a South region problem as well. We know there aren't very many processors operating for all kinds of reasons, and anything can happen. And this is a tool that would have to be used under those circumstances, which is why we brought it up under this agenda item, in case people are wondering about that. So to answer your question, we believe in regional delivery requirements, but we need a better, more durable process or tool to guide everyone in these difficult times.
Thank you for your testimony.
Thank you.
So next up is Cory Lescher, followed by Mateo Paz-Soldan.
Good morning, Madam Chair, members of the council. For the record, I'm Cory Lescher with Alaska Bering Sea Crabbers. ABSC is a trade association that represents the majority of independent crab harvesters who commercially fish for king, snow, and tanner crab with pot gear in the Bering Sea and Aleutian Islands Crab Rationalization Program. I want to thank you this morning for the opportunity to provide our comments. First, I'd like to acknowledge all the work by Mr. Brannon in putting together the analysis and the presentation that he provided yesterday. Alaska Bering Sea Crabbers submitted a comment letter under this agenda item, and for the sake of brevity, ABSC aligns with the comments you heard earlier this morning from Mr. Foe in the public comment letter submitted by Mr. Foe and the Intercooperative Exchange. Thanks, Madam Chair. That's all I have for this morning.
Thank you very much for your testimony. Are there any questions? Seeing none, thank you. Mateo Paz-Soldan is our last testifier on C1.
Thank you, Madam Chair, members of the council. My name is Mateo Paz-Soldan. I'm here on behalf of the City of St. Paul, one of Alaska's principal crab harvesting and processing communities. I would like to first of all thank the analysts, Daryl Brannon and Sarah Marinan, for their work on this action. They have been extremely responsive and accessible throughout this process. The outreach to the arbitrators was especially helpful and brought useful considerations to this council. Daryl was tasked with a very difficult assignment, it seems, to search for a miracle cure to the crab program's ailments. It was a difficult task, but he did a great job and it is appreciated. We also support the previous comments by CBSFA, St. Paul CDQ Group. As someone who was involved on the city's behalf 25 years ago in building the crab rationalization program and its foundational structure, it is difficult to see that structure, the very home we built, now in such disrepair. And this binding arbitration action feels like an effort to salvage some remaining aspect of that structure and to extract some valuable items from it, even as we all recognize at this stage that the house that we built is not coming back. It is much like the changes now affecting our broader society and our ecosystems. Hard to accept, yet undeniable, and harder still to confront the reality that what is happening and has happened is in many ways irreversible. Just like nations and empires, fish management programs rise and fall. But there are things that endure and that do not change. And those are our 10 commandments, the Magnuson-Stevens Act and its national standards, which are grounded on agreed upon fundamental principles that we as stakeholders all share. We may differ at the margins in how we interpret them, but we are united in the core concepts: fairness, protecting our precious resources, equity in allocations, ensuring the survival of our beautiful coastal communities, the safety of our fishermen, and taking care of those who, for historic reasons, have been disadvantaged. The national standards and the careful balancing of them permeated the construction of this program 25 years ago. They were very much at the forefront of the minds of the architects of this program. I was recently reading a statement of Kevin Duffy, former ADF&G commissioner, made at the hearings before the U.S. Senate in May 2003 on this exact subject. And every aspect of this program, binding arbitration included, as well as relief from regional landing requirements, was shaped by the balancing of those national standards. Let me quote Commissioner Duffy for the state of Alaska to Senator Stevens, Murray, Cantwell, and Lisa Murkowski on that day 22 years ago. On binding arbitration, he said, "Similar to fishermen, processors have concerns that they will be price takers. Currently, some processors estimate that fishermen capture upwards of 87% of the wholesale price of crab. Crab harvesters are organized under the 1983 Act into a monopolistic bargaining association and negotiate price as one entity, while processors are not similarly organized. This perspective suggests that, like beauty, bargaining strength is in the eye of the beholder, or the potential loser in this case. Nonetheless, emphasis added, the Council's approach to binding arbitration, data collection, and program review is aimed at protecting the processor sector as well." End quote. So today we must ask the question as we review the binding arbitration tool. Does it still protect the processing sector? And we must be clear about what the processing sector is today, because it is not what it was 25 years ago. Much of that sector is now community-based and consists of CDQ groups that have invested directly in processor quota share. In CBSFA's case, it is now the second largest holder of snow crab IPQ in the North region. And this evolution was not accidental. It was by design. It was the express intent of the Council's action in 2005, but also of the CDQ statute to use Alaska's resources to promote the development of Western Alaska villages. Immediately after the discussion of binding arbitration, Duffy turned to the program's community protection measures. He recognized the substantial investment of communities in the development of the Bering Sea crab fisheries and warned of the very real likelihood of irreparable harm without protection, while noting National Standard 8 directives. These community protections included expanding the CDQ program to all crab fisheries under rationalization, increasing the CDQ allocation from 7.5% to 10%, allowing non-CDQ crab-dependent communities to purchase harvesting and processing shares, and granting those communities rights of first refusal if processing shares sought to leave. The program also established North and South regions to protect historical delivery patterns and attached regional designations to Class A shares to protect processing quota shares. Deliberate structural safeguards, he said, to anchor economic activities in the communities that have historically depended on these fisheries, and responsive to national standards 4 and 8, as well as the trust responsibilities to Native communities like St. Paul. And then the state of Alaska's representative added what is so relevant right now. He explained that although processor shares are typically viewed as part of the second pie, their issuance has direct implications for the protection of a community's processing base. He cited Alaska's prior experience with harvester-only allocations, showing a dramatic reduction and shift in shore-based processing. While the causes are complex, the state concluded it was sound policy to minimize those impacts. He stated plainly that the more processors that survive that transition to a rationalized fishery, the stronger the community's economic base will be. And in his words, the processor pie helps make the community pie whole. So bringing all this back to earth, to the action before us, we support the comments made earlier by CBSFA. The most controversial element is obviously option 1 under alternative 2. We don't know whether that change will bring meaningful relief, but to the extent that it does, that it makes a difference in whether a processor opens in a season or not, the city of St. Paul supports that. We want that processing activity back on St. Paul. And finally, St. Paul is a community of harvesters. It's a community of fur seal harvesters in the past, a community of halibut harvesters. So that's in our blood, it's in our DNA, and they understand how important keeping that sector alive and healthy is as well. Thank you.
Thank you very much for your testimony. I'll see if there are any questions. Seeing none, thank you so much.
I have a link to that, the record of that hearing, if you all are interested. It was
Yeah.
very, very useful to read and so
Yeah.
applicable to what's going on today.
Yeah, thank you very much for sharing that.
Yeah.
It was very interesting. Thanks. So with that, that concludes our public testimony on C1. Let's come back at 10 a.m. And see if the council would like to take action on this agenda item. Thank you. Welcome back, everyone, and we appreciate your patience and allowing us a little bit more time here. We have received our presentation, public testimony on C1, and I'll ask the council if they would like to take action on this agenda item. Yes, Ms. Baker.
Thank you, Madam Chair. I have a motion that has been sent and received by staff. I'll wait for that to post on the screen. The council adopts the following alternatives and options for final action with the following revision, addition underlined. Alternative 2, changes to the regulations governing the arbitration process. Option 1, remove the requirement that the arbitrator can only select a remedy proposed by one side. Allow the arbitrator to select an independent or compromise remedy based on the facts provided in the arbitration. Option 3, remove the requirement for a market report. Option 5, streamline the information submitted to NIMS in the annual arbitration organization report and notifications by removing requirements for information NIMS already has, information that has not changed, and any other information that is no longer necessary. Alternative 3, IFQ and IPQ application withdrawal. IFQ and IPQ applications can be withdrawn after being accepted by NIMS at any time before BSAI crab rationalization species tax are announced and within option 2, 48 hours after BSAI crab rationalization species tax are announced. The council encourages arbitrators to provide a written rationale to the parties to the arbitration. The arbitrator would be responsible for ensuring that the rationale is consistent with applicable antitrust laws. With a second, I'll speak to the motion.
Thank you for the second, Ms. Kimball. Ms. Baker.
Thank you, Madam Chair. I'll try to be relatively brief. We've had a lot of conversation about this issue. I just want to start by really expressing my appreciation to the analyst and to everyone who testified on this issue over the time period that we've done this. It's clearly challenging, and we're dealing with a pretty novel program here, as we often are. And so I'm sure we'll have a lot of discussion related to this. But so first I'll go through the proposed preferred alternatives and options, just provide a little bit of rationale there. Regarding alternative 2, option 1, to remove the requirement that the arbitrator can only select a remedy proposed by one side. I was considering all the information that we received in the analysis and in testimony. I was really persuaded that the uncertain liability from potential arbitration really has resulted in some processors making difficult decisions regarding whether to operate, and that providing some flexibility by removing the requirement for last best arbitration could remove some of the risk related to arbitration. I think based on the information we received in the analysis, and the testimony that we received to really provide expertise related to these circumstances that we're trying to deal with. I do want to acknowledge that I think there is some potential under alternative 2, option 1, to potentially change the first offers that each party provides under the arbitration if we remove LBO arbitration. However, I think considering all the factors we've heard through the analysis and testimony, I'm not convinced that those differences would be substantial enough to really fundamentally change the program at this point in time. I acknowledge, as we've heard about, we heard from the analyst and in testimony, there's not experience that we can directly point to that will give us a strong likelihood of knowing exactly what will happen. But I really feel like I've I've considered all sides of the issue. I fully understand the concern about moving from last best arbitration and the very solid reasons that that was selected at the time the program was implemented. I think fundamentally circumstances have changed in the crab fishery that warrant what I consider to be a minor change to the style of arbitration. And so I'm including alternative to option 1 in this motion. Alternative to option 3, to remove the requirement for a market report. I think the analysis and public comment very clearly supports the benefits from doing that. The market report, just again, due to differences in information available now versus when the program was implemented, really is redundant and not timely, and can really result in a more efficient arbitration program if we remove the market report. Same with option 5, to streamline the information submitted to NIMS. And really appreciate that we were able to take this option 5 from our seafood competitiveness executive order considerations that we took up the last meeting, and finding ways to streamline and make our regulations less burdensome and more efficient where we can. And I felt like the analysis did a really good job of covering what benefits we would receive by including this option in our preferred alternative, and I support it. And there's really nice tables 317 and 318 in the analysis that lay out what actually would be streamlined and could potentially be removed under this option. Moving along to alternative 3, IFQ and IPQ application withdrawal. Again, I think based on the information and in the analysis and the testimony that we heard, I really think that selecting this alternative improves transparency of the status quo by establishing a timeline in which fishermen and processors can withdraw their applications for annual IFQ and IPQ up to 48 hours after the TAC announcements. And we've talked a lot about recalling that processors must apply for quota by June 15th, which is months prior to when the crab stock assessments are done and the TACs for each crab fishery are announced. And this really means that processors are really having, they have a lot of uncertainty related to whether they'll have a viable operation for the upcoming season. And so, as we've talked about also, under the status quo, applications have been submitted and allowed to be withdrawn by NIMS. And so selecting this alternative, I think, just provides some clarity about what the process would be for allowing applications to be withdrawn for both. We've talked a little bit about in this action, it seems more likely given current circumstances that the decisions will be around whether withdrawing IPQ applications, but I would note that this alternative also provides a process for withdrawing IFQ applications. And finally, the addition to the preferred alternative that I'm proposing, you'll notice I have not included alternative to option 2 in the motion to require an arbitrator report or written rationale to the parties to the arbitration. I think some of the concerns that were very clearly articulated in the analysis related to how to determine what information could be included in such a report and rationale to avoid antitrust concerns. I found that, again, pretty persuasive and created some concerns. And I just think the urgency of this action in providing a little bit of flexibility to the binding arbitration process with both alternatives 2 and 3, as I've laid out here in the motion, is really important to try to move this forward as quickly as possible and provide some of that flexibility. And I was just very concerned about, although I think at least written rationale from the arbitrator for providing some reasons for decisions, even if it's general, could certainly be helpful. And I appreciate the testimony we received and I agree with that. I think it was just very concerning to me, given the concerns about what that report looked like and our inability to sort of get at that with clear specificity at this point led me to encouraging arbitrators to provide a written rationale, which I will just clarify is not a requirement of this motion. I wouldn't expect it to be in regulations. It would just be encouraging the council encouraging arbitrators to do so. That, Madam Chair, I just kind of generally, I wanted to go through the elements first to lay out my thinking there. But overall, I just really wanted to speak to the difficulty of this action, again, acknowledging it, appreciating all the participants and their contributions to it. I just really think this is prompted by the really challenging and variable conditions in the Bering Sea crab fisheries that have been ongoing in recent years and continue. And I really think, all on balance, that this motion that I'm putting forward reduces the uncertainty somewhat associated with the arbitration process so that it can function as a balance tool for both parties. I really was persuaded by the testimony and input that we received that this action could facilitate crab processors having a little less risk in terms of arbitration, and that might result or make a slight difference in decisions whether to apply for IPQ on an annual basis, given some of these really challenging conditions that the crab fisheries are currently experiencing and unfortunately are projected to continue for a while. I think fundamentally, what really persuaded me was the input we received from Alaska shore-based community representatives who are on both sides of this issue and really are at the cornerstone of what the crab rationalization program was meant to accomplish and meant to achieve. And we were really nicely reminded of that in public comment today. And so I understand the concerns about changing the binding arbitration program, which is an important component of this program. I think these changes I'm proposing are minor. And so I'd be happy to answer any questions, Madam Chair.
Thank you very much, Ms. Baker, for the motion and the rationale. I'll see if there are any questions. Yes, Ms. Kimball.
Thank you, Ms. Baker, for your motion and for the explicit rationale. I guess maybe just to reiterate the last couple sentences that you have outlined. You mentioned they're not intended to be in regulation. They're just kind of a statement of encouragement. I really was reading the analysis as it is very possible to provide both a written report and rationale without including anything that would spur antitrust concerns. So I just want to understand your rationale a little bit better. Is it really the morass it seemed to create in review that pulled you toward not including option 2 in the regulatory package, but just making a statement of encouragement?
Thank you, Madam Chair, and thank you, Ms. Kimball, for that question. Yes, I interpreted the analysis to suggest and indicate that, yes, it would certainly be possible to require a written report and rationale to the parties to the arbitration, who would still be bound by requirements to maintain the information in a confidential manner. Those would still exist. However, it was really, I think, given, some of the circumstances we've encountered in terms of the complexity of reviewing something related to antitrust, which we encountered with implementation of the crab rationalization program, I was a little bit concerned about if we included alternative to option 2. And just in terms of NOAA General Counsel, Ms. Watson spoke to it yesterday, in terms of NOAA General Counsel not being able to advise on antitrust issues. And so I was a little bit concerned about that, including alternative to option 2, potentially delaying moving forward this action as a whole through the process. And although I think a written report and rationale could be potentially valuable, would be potentially valuable, I think on balance, it was more important to move forward with the motion that I have here with a little more certainty about how it could move through the review process.
Thank you. Any other questions on the motion? Ms. Watson?
Through the chair, thank you. I have what will hopefully be a easy question for Ms. Baker. So for the additional language that the arbitrator would be responsible for ensuring that the rationale is consistent with applicable antitrust laws, I just wanted to confirm that what we're requesting be consistent with antitrust law is the information that would be released in that written rationale. Is that correct?
Through the chair. Thank you, Ms. Watson. Yes, that's good.
Thank you. Any other questions? Okay. Are there any comments? Are there any amendments to the motion? Yes, Mr. Carlin.
Thanks, Madam Chair. I will support the motion. I want to express appreciation to Ms. Baker. Sorry, is there a... Okay. Express appreciation to Ms. Baker for her motion. I agree with her that aspects of this are directly supportive of the executive order on restoring seafood competitiveness, specifically streamlining some of the administrative requirements, which is one of the goals of that executive order. I want to note appreciation for the creative solution to addressing the concepts behind alternative 2, option 2, without running afoul of antitrust concerns. That really not having that part of the rulemaking avoids the issue that Ms. Watson and I had raised yesterday. So appreciate that approach, and I'll be happy to support the motion.
Thank you, Mr. Carlin. And we'll go to Mr. Pamplin.
Great. Thank you, Madam Chair. Ms. Baker, appreciate your work on this motion. I also intend to support it. Just following the remarks, I also really appreciate the work by the entire team on this thorough analysis and the extra meeting that I had scheduled with staff to further understand this issue as I kind of came on midstream of a very complex issue. In regards to alternative 2, option 1, I understand the benefits of last best offer, as well as the uncertainty that Ms. Baker acknowledged and the inertia of status quo. But I do think there are benefits of the arbitrator having the flexibility to select not only the binary option presented by the two sides, but to craft a compromise by pulling elements from each proposal. Ms. Baker, I also appreciate the proposed language that you've offered for the written rationale. I think that's a good solution to that issue. So with that, Madam Chair, I do have a deeming amendment. So folks can pull that up or I can just read it off. So
Looks like Danielle's pulling it up. There we go.
great. We got to find it here. So the council deems proposed regulations that clearly and directly flow from the provisions of this motion to be necessary and appropriate in accordance with Section 303C. The council authorizes the executive director and the chair to review the draft proposed regulations when provided by NIMS to ensure that the proposed regulations to be submitted to the secretary under Section 303C are consistent with these instructions.
Thank you for the second, Ms. Vanderhoven. Mr. Pamplin, would you like to speak to it?
Thank you, Madam Chair. No, this is pretty straightforward. There's a couple options that we have, and I think it's appropriate here that this just comes back to the executive director and the chair to ensure it's consistent. Thank you.
Thank you, Mr. Pamplin. Are there any objections to the motion or the amendment? Okay. Seeing none, the amendment passes without objection. We'll go back to comments on the amended main motion. Mr. Williams.
Thank you, Madam Chair. First, let me say, as others have, thank you to all who worked on this, and particularly to staff and others who spent a considerable amount of time with me trying to answer questions and help me understand what this whole process was. I listened intently, particularly today, but also yesterday, as we here at the council asked Mr. Brannon a number of questions, probably an hour's worth of questions at least yesterday. I think Mr. Paz-Soldan made the statement that Mr. Brannon was trying to come up with a miracle cure, which I thought was an interesting way to characterize it. But as I listened to Mr. Brannon answer our questions, almost every one was a maybe, could, might. They were all uncertain. I'm going to say right up front that while there are certainly pieces of the motion, so particularly alternative 2, option 3, 5, and then alternative 3 that I certainly support, I'm going to be able to vote for the motion here today. I think the benefits from changing the arbitration process at best are speculative. Some said that the benefits from changing the arbitration are minor changes. I don't personally believe they are minor changes. I think again, we don't know what will happen. I think potentially what I would call a fairly efficient and timely process we have today that fits within the kinds of timeframes, the crunch timeframes that are put in place for setting these fisheries up, I think we may sacrifice some of that. And I truly believe that we are going to see some increased costs, particularly if arbitrations become more normal or more time. Well, there's more of them than there used to be in the past. Anytime you have to hire lawyers to do something, it gets damn expensive and can be a challenge to get things done. So for those reasons, I am going to vote no, largely because I think the unintended consequences could be large here. So thank you, Madam Chair.
Thank you, Mr. Williams. Are there any other comments? Ms. Goen.
Thank you, Madam Chair, and thank you, Ms. Baker, for the motion. And I'm going to align myself with Mr. Williams' comments and also want to echo the thanks to staff for all their work on this. However, I cannot support it largely because of the inclusion of alternative 2, option 1, to remove last best offer arbitration. We've heard through the agenda item that all crab fishery stakeholders, harvesters, processors, and communities are struggling and facing extreme difficulties. That's clear. What's not clear is how to fix these core issues stakeholders are facing. The motion's not getting at these core issues of strains on the cost of doing business under this program for everyone when crab tax are low and the lack of shore-based processing facilities willing to handle and process crab. When looking at solutions to create relief, we need to also be looking to maintain the balance of power between harvesters, processors, and communities in this program. This motion erodes that balance of power and is fundamental and substantial change to the program, and it harms harvesters. What we're dealing with is a lack of shore-based processor availability throughout Alaska, and not just for crab. Other fisheries like the new trawl cod program called PCTC and the halibut sablefish are experiencing it too. This action is not fixing that, and I would encourage us as a council to prioritize trying to figure out if we have a role in helping to address this issue across Alaska's fisheries. Specific to this action, the analysis states that last best offer incentivizes reasonable offers and efficiency, and removing last best offer and moving to alternative 2, option 1 is expected to increase costs, take more time, and is not expected to increase the quality of the outcome, as we saw in the analysis. So then why make that change when we've only experienced 3 arbitrations in roughly 15 years and processors have won arbitrations under last best offer? I do not think that applause is for this. This agenda item claims the risk of arbitration and not applying for IPQ with the last best offer system, but in practice, we haven't seen that happening. Plus, the risk of arbitration is still there under option 1 of this motion under standard arbitration. So it's unclear that this change will fix the difficulty processors are experiencing. Moving to option 2, I appreciate the creative solution there in addressing the written report and reducing antitrust concerns. Option 3, to remove the market report's an easy one and everyone agrees, so that one I appreciate. And I also appreciate that you didn't include option 4 on non-performance. Under alternative 3, option 2 to withdraw within 48 hours, we heard general support from harvesters for this element as long as it includes important protections for harvesters by preserving the lengthy season agreement process and the right to arbitrate. And I want to be clear that I'm sympathetic to processors experiencing increased costs. I truly am. And I want to help find solutions that work for everyone. I appreciate the public testimony and comment letters on this tricky issue. And everyone is experiencing increased costs, harvesters included. We need to be looking for solutions that are addressing the fundamental problems we are facing in the crab rationalization program, the lack of available processors, and how the program functions under low crab harvest levels. We've heard some ideas under this agenda item that could be considered moving forward, including what do we do if no IPQ is issued? That needs to be figured out. Or addressing improvements to emergency relief from regional delivery requirements to facilitate that process while still keeping it flexible. That flexibility has proven to be critical here in recent years. And I believe we're going to be hearing other ideas under the C-Shares agenda item that we might need to be considering. While the council does not have the equivalent of an IFQ committee for crab, the crab industry and stakeholders are encouraged to be working together to figure out potential solutions that could help all parties, especially during times of low quota, and what could facilitate more access to processing facilities. Thanks.
Thank you, Ms. Goen. Any other comments on the amended motion? Mr. Sakana.
Yes, thank you, and thank you, Ms. Baker, for the motion. I will be supporting the state's motion. I do believe that these are practical adjustments that strengthen the crab program without really changing its core. I understand that the price formula and the revenue shares remain fully intact. I personally couldn't find any single, that's a dangerous word to say, but I couldn't find any examples of LBO being used in resource development, specifically fisheries, but in also other natural resource sectors. I do believe that while anchored on the revenue, it is a multi-factor environment, timing, places. There's lots that can be used, I guess. So it isn't just a single number like baseball often is over salary. I think this will remove some of the downside risk and improve stability for the processors' participation in the program. I do appreciate that the motion does not include option 4. Removing non-performance arbitration would have created some serious exposure for IPQ holders without a plant, and we heard from communities as well as processors, 2 out of the 3 legs of that stool. I am a little disappointed that we couldn't get the written report in, but I certainly understand why. So I guess I'll just close by saying that I will be supporting the state's motion because of those factors.
Thank you, Mr. Sakata. And Ms. Kimball.
Thank you. I'll be brief, align myself with Mr. Sakata's comments. I'm also fairly disappointed we couldn't find a way to have the parties understand or be required to be provided a written rationale so they understand the decisions. But I very much appreciate Ms. Baker's work to try to get to something like that. And I realize it just couldn't be done in a regulatory fashion that would ensure that the rulemaking went through smoothly. So I see the path that she took, and I am supportive of that in the long run. I do think that this is important to take, while it may be a small change in my mind to the arbitration process. I echo other people's comments that it doesn't remove the price formula. It preserves arbitration. All it does is allow the arbitrator to choose an outcome that may be different from what the 2 parties brought to the table. I think there's a real strength in the fact that both processors and communities, 2 legs of this stool, are seriously asking for this. They're not asking to throw out other pieces of the program, but they're asking for this little bit of flexibility. And I think they're telling us very directly that it does have an effect on people's ability or their decisions to operate. It has an effect on their ability to apply for their quota and an effect on their ability to withdraw their quota. And I think if anything, that's important to recognize. And I agree with Ms. Goen and others that there are other big problems in the program structure that we haven't addressed through this action, but I think we're taking a small step to mitigate that risk. And I feel like that's lost in some of the detail of the analysis, where overall we are looking to preserve a program that has an operational crab fishery where harvesters are able to deliver to processors in Alaska. They're able to put that product on the market, and communities derive all the benefits from not just tax revenue, but support services and everything else. It really struck me in the community testimony how linked those two things are. And I really appreciated actually all the testimony today in explaining the public's positions. I wanted to just note from the analysis, I don't think Ms. Baker spoke to it, but we do have a section on the changes in net benefits to the nation under all of the options that she selected in her preferred alternative. Under alternative 2, the overall change in net benefits is expected to be about 0. Under option 1, I actually think it'll be positive, much more positive than's reflected in the analysis if people continue to apply for their quota and we have more processors, not fewer processors operating in the fishery. I also think obviously there's some positive net benefits as reflected in the alternative under option 3 and under option 5. Also under alternative 3, the net benefits may be uncertain, but I think the analysis is clear that that's just reflecting a change in transparency through the process to withdraw quota. And the only situation in which there may be something significant is if all IPQ holders withdrew their application. And that's possible under alternative 1 as well. And I think all the actions we're trying to take here today are to mitigate that risk such that we're not in that situation. So I very much appreciate the motion, and I'll be in support.
Thank you, Ms. Kimball. Yes, Ms. Baker.
Thank you, Madam Chair. And just very briefly, since we are at final action and I didn't speak to this in my initial comments, I just wanted to confirm that I think, and I would submit the motion as we have in front of us is consistent with the national standards and the Magnuson-Stevens Act. I think the analysis in section 4.1 outlines the ways in which that's the case. And I just wanted to highlight in particular, I think that this action would be consistent with national standards 5, 6, 7, and 8. And just very briefly, I think those national standards particularly deal with the proposed changes we're considering here, consider efficiency of utilization in terms of we're reducing some regulations here that are no longer necessary. In terms of National Standard 6, we're providing some clarification in terms of the process for withdrawing IPQ and IFQ applications. National Standard 7, again, minimizing costs and avoiding unnecessary duplication. Alternative 2, options 3 and 5 are very consistent with that. And I think, as I spoke to earlier, particularly National Standard 8, to ensure that management measures are consistent with taking into account the importance of fishery resources to fishing communities. And I feel like this action really takes a step to ensure that our crab rationalization program is consistent with National Standard 8. Thank you, Madam Chair.
Thank you, Ms. Baker. And Mr. Ritchie.
Thank you, Madam Chair, and sorry for the late hand. Thank you, Ms. Baker, for the motion. I have been conflicted on this. This is a difficult one. Testimony helped my decision here a lot, so I want to thank testifiers. I also want to thank Mr. Williams and Ms. Goen for their comments. I think that those are real concerns that everyone pays attention to and care about, but I think that a lot of those are concerns over things that may happen. And for me, what helped me make my decision is that we heard from testifiers with concerns of things that have happened, that have been realized and are impacting both the intent of the rationalization program and communities that are directly affected in very negative and real ways. And for me, that matters. So I'll be supporting the motion, but I hope that the concerns that you've noted and were noted in testimony, I hope that those things are never realized. Thank you.
Thank you, Mr. Ritchie. Any other comments? Yes, Mr. Mueller.
Yeah, thank you, Madam Chair. Yeah, I too was struggling with where I was going to land on this particular action item. And I want to thank the public for particularly the history lesson, taking us back to, some of the original intent and some of the comments made by the folks that were at the table during that time. And also Ms. Kimball's comments relative to the three-legged stool that we have in front of us. Again, it's a extremely sensitive issue that we have in front of us today, but Ms. Kimball's comments and members of the public's comments relative to the stability from a processor and community standpoint were really compelling to me. And so for those reasons, Madam Chair, I'll be supporting the motion. Thank you.
Thank you, Mr. Mueller. Any other comments? Okay. Okay, seeing none. Thank you, Ms. Baker, for the motion. I appreciate all the work that you put into this, as well as all the public testimony that we've heard on this issue, which is quite complex for parties not involved in the CREP program in particular. This council clearly recognizes the importance of maintaining healthy sectors in the crab fishery for harvesters, processors, and communities. That's very clear from the conversation and our interaction with the public. I think this body also clearly understands the importance of preserving the arbitration process within our current share matching structure as a mechanism to provide a fair and transparent framework for disputes when they arise. So this motion, as Ms. Baker stated, does not change that fundamental structure. Instead, it includes some small but important changes that allow greater flexibility in response to evolving market conditions, resource variability, and shifting economic realities. We heard in public testimony about the current imbalance and the various dynamics between the harvesters and processors, and the strain that this has put on the viability of participants in all sectors. So I think this motion is really important in that it takes an incremental step in helping to promote the long-term sustainable participation of all sectors in the fishery. So I'll be in support of the motion. Thank you again, Ms. Baker. So with that, I think we need to take a roll call vote, and I'll hand it over to Ms. Evans.
Members of the council, we're doing a roll call vote on final action on the crab arbitration analysis with the recommendation to adopt options 1, 3, and 5 for alternative 2, alternative 3, and an additional statement on encouraging written rationale. Ms. Baker.
Yes.
Ms. Goen.
No.
Ms. Kimball.
Yes.
Mr. Kurland.
Yes.
Mr. Mueller.
Yes.
Mr. Pan.
Yes. Yes.
Mr. Sukata.
Yes.
Ms. Vanderhoven.
Yes.
Mr. Williams.
No.
Ms. Drobnica.
Yes.
That motion passes 9-2.
Thank you. Any further action on this agenda item? Okay, seeing none, we will move to our C2 agenda item, and we can begin staff presentation if we have staff available. Great. Thank you, everyone. Thank you. Ms. Holman, please begin when you're ready. Thanks.
Thank you, Madam Chair. And good morning, Madam Chair, members of the council. For the record, Taylor Holman, council staff, and I'm here to present agenda item C2, which is on crab crew shares. This document is an analysis for final action. You last saw this item back in October as an initial review document. And today, as I said, you'll be taking final action or a recommendation on this item. So because you just saw this back in October, if I stay on script, it will be an abbreviated presentation since it was just seen at the last council meeting, and I'll primarily focus on the new content and the analysis. This slide highlights the new content that was added since October, including a couple items that were highlighted for council consideration. These are available in the executive summary and will be discussed later in the slide deck. In the Summary of Substantive Issues chapter 3, there's an increased discussion on the value of C shares and a bolstered analysis of impacts in chapter 4, including section 4.2.4 on alternative 2 and discussions within alternative 3 to help the council decide between that use cap increase that is part of alternative 3. All right, just for a quick introduction and background, this purpose and need statement for action was adopted in December of 2024, and it was unchanged in October. The full statement is included here for reference. I won't read the entire thing for you, but just some highlights. The purpose of this action is to increase opportunity for active crab fishermen by increasing flexibility and encouraging new entrants. This is intended to potentially incentivize the transfer market and increase the marketability of sea shares in general. It's also intended to provide greater consistency between the participation requirements to retain and transfer sea shares, as well as loosen restrictions on use caps. These alternatives selected for analysis were also adopted in December of 2024 and were unchanged after the initial review of this analysis in October. The action alternatives were selected as ways to increase flexibility and encourage new entrants, consistent with the purpose and need statement. The action alternatives read as follows. Alternative 2 would revise eligibility requirements to purchase or receive sea shares by transfer by allowing time tendering in any federal or state commercial fishery off of Alaska to count towards the 150-day eligibility and increase time to 3 years to participate in a CR fishery trip. Alternative 3 would increase sea share use caps for Bering Sea crab stocks. It asks to consider increases of up to 5 to 10% individually for each Bering Sea crab stock. The two action alternatives are not mutually exclusive, and no preliminary preferred alternative was selected in October. I will note that the council did clarify within the rationale in the October 2025 motion that alternative 3 should be interpreted as increasing the use caps for those Bering Sea crab stocks to 5 to 10% rather than increasing them by 5 to 10%. And that has been reflected in the analysis accordingly. All right, the following slides will just give a brief background on the fisheries, the management structure of those fisheries, and participation trends. So first, section 3.2.2 in the document discusses sea share eligibility requirements. First, those transfer eligibility requirements that would be modified by alternative 2. In general, sea shares are transferable only to CR program fishery crew, with a couple more stipulations and limitations that further diminish that pool. You have in the first sub-bullet that crew member must be a U.S. citizen with at least 150 days of sea time as part of a harvesting crew in a U.S. commercial fishery. And they need to have participated as crew in one of the CR program fisheries within the last year. Once an individual has obtained sea share QS by transfer, they then need to continue meeting retention eligibility requirements in order to have that sea share QS continue yielding IFQ. Sea share QS will yield IFQ only if that individual has participated as crew in at least one fishing trip where a delivery of crab in a CR program fishery occurred during the 3 preceding crab fishing years, or participated in this crew in at least 30 days of fishing, tendering, or both in combination. And that needs to be Alaska specific fishing or tendering. Now, these participation requirements were modified in 2024 through Amendment 54. Now that 30 days of fishing, tendering, or both in combination, that can be used by both an initial recipient and new entrants. Tendering was also added in that Amendment 54. All right, next, section 3.2.3 in the document discusses the current sea share use caps, and these would be modified under Alternative 3. So individual use caps are imposed on the use and holdings of harvest shares by any person in order to prevent excessive consolidation of shares under the program. They vary across the CR program fisheries, as you'll see on the slide, due to differences in fleet characteristics and differences in the historic dependency of participants on the different fisheries. These are calculated as a percent of the initial sea share pool, which is 3% of the IFQ that's allocated in the CR program. These are then applied to the total QS units within the initial QS pool for CVC and CPC. So in this table, you'll see those caps for each fishery. In that second column, the number of CVC and CPC QS holders as of the 2025-2026 crab year in the middle column. And then on the right, you see the number and percent of those individuals that have holdings at or above the individual use cap. The individuals that are above the individual use cap, those are individuals that were grandfathered in at the start of the CR program.
Sorry to interrupt. We have a question for you, Ms. Goen.
Thank you, Madam Chair, and thank you, Ms. Holman, for the presentation. My question's actually back a slide on number 7. And just clarification that for the transfer eligibility requirements, that's an and between the two bullets. In other words, they have to do 150 days and participate in a crab rationalization program. I know one of the comments that you'll see or that we see in the letters submitted is making sure that they stay active crab fishermen in this fishery.
Through the chair, Ms. Goen, yes, you are correct. The transfer eligibility requirements, individuals need to meet both of those sub-bullets, whereas, so they need to meet the 150 days of sea time as part of harvesting crew, and they need to have participated in one of the CR program fisheries within the last year. The retention eligibility requirements, that's where you get that that or piece, where you either need to have participated in as crew in the CR program fishery or 30 days of fishing or tendering in another Alaska-specific fishery. All right, so here I'll pivot to some of the issues that are driving this action. So sea share transfers of harvest QS in general have been low in recent years, and for the sea share market specifically, that has essentially stagnated. These issues are described further in section 3.4.4 of the document. And the limited transfers are essentially a result of uncertainty in the fishery. You have persons that are holding harvest QS that don't want to sell at a low price relative to historical rates. And on the other side, you have buyers who don't want to pay more than they expect the quota to provide in future profit streams. This slide highlights a couple, a figure and a table in the document, figure 3.6 and table 3-17, that represent the number of transfers. Figure 3-6 represents all harvest QS transfers. So that's for sea shares and for CVO. And the table 317 breaks it out, so it's only CVC QS transfers. You'll see that the issue that's described about limited transfers as a result of uncertainty in the fishery, that is exacerbated for sea shares because that buyer pool is directly impacted by declines in fishery participation that we've seen over recent years. So we have this direct link between the eligible buyer pool and participation due to those transfer eligibility requirements that were described on a couple slides back. So you have indicators that like prior year vessel counts, employment counts, and available positions, which are all described in section 3.3, which all have a direct impact on the pool of eligible buyers. This is a new section in the document. and discusses the value of C shares and how owning C shares can provide monetary value to shareholders through three main channels. So in that first bucket, you have individuals who are directly harvesting the raw crab pounds themselves. If so, the value of owning C shares would be reflected by the ex-vessel value of that crab. Now, in the document, the tables of value reflecting ex-vessel value do not account for operational costs. Those values shown are the gross and not net costs. That's because calculating true harvest value can be complex, especially if the C shareholder is not a vessel owner. In those cases, the value may also be reflected through things like additional leverage and contract negotiation. The second bucket here is individuals who are leasing their IFQ annually. So C shareholders that lease their IFQ are paid a proportion of the total ex-vessel earnings of the harvest. So that proportion is known as the lease rate. So for those individuals, the value of owning C shares is reflected in the proceeds from leasing that C share IFQ. Now, I note here that lessees must meet the C share QS transfer eligibility requirements. Those apply to QS and IFQ, since they are also receiving C share IFQ by transfer. Finally, for individuals who opt to sell their underlying QS units and fully or partially divest from the fishery, the value of owning C shares is reflected in the sale price of that QS transfer. Okay, so the next section discusses the expected effects of the alternatives in Chapter 4. So for Chapter 1, for Alternative 1, the no action alternative, there were a number of challenges and problems that are facing the BSAI crab industry that were discussed in the most recent crab program review. And if those challenges and problems persist, then challenges surrounding C share markets and participation would continue due to that direct link in the buyer pool between participation trends and the size of the buyer pool. So you have these low transfer volumes that are occurring in the C share program, and the current market has little to no demand. Again, you have that limited buyer pool, which dampens demand, and the restrictions on the buyer pool would remain in place under Alternative 1. Conversely, if crab stocks improve, fisheries open, and tax provide more opportunity, then C share markets may somewhat stabilize. The restrictions on the buyer pool would still remain in place under Alternative 1 and may continue to constrain the value. And requirements to retain C shares may continue to dampen interest and demand for individuals in that buyer pool. But I'll note here that the additional flexibility through Amendment 54, through modifications to the retention requirements, does not change the buyer pool, but may alter the decision calculus of individuals who are already eligible to purchase C share QS. Under Amendment 54, a C shareholder can be issued IFQ annually and retain their C share QS without continued CR program participation. So the additional flexibility that's granted through that amendment may impact the demand and prices, but the magnitude of these impacts are unknown due to the recency of that amendment.
I have a question for you, Ms. Holman.
Oh, thank you.
Ms. Kimball.
Thank you. Took advantage of you taking a sip. My question is just trying to understand better the relationship of the expected effects of Alternative 1 to the use cap issue. And I guess I'm trying to find in here what's the problem that we've established that we would be addressing by increasing the use caps. I don't see it in the purpose and need statement, which I know is our own, but I'm also having trouble finding it in comparison to Alternative 1.
Thank you, Ms. Kimball, through the question, through the chair. In the purpose and need statement, there is a small piece at the very end about loosening restrictions on use caps. And that by loosening restrictions on use caps, that may also kind of unlock individuals who have already proven interested and able to purchase C share QS. So that may kind of spur some transfers to occur and allow current C shareholders to acquire additional C shares, which is also consistent with the purpose and need statement. I hope that answers your question.
Thank you. It does. I still didn't really see the problem established in the purpose and need statement relative to that alternative, but in your response then, are we talking about opening it up to in your table on slide 8, opening it up to the 16 existing holders of red king crab or the 16 holders of snow crab? Is that who we're talking about that are at the cap that could then continue to buy up more sea shares?
Through the chair, Ms. Kimball, yes, that is who would be impacted by alternative 3, and I can get into that a little bit further in later slides, but yes, the transfers that would be spurred through alternative 3 would only really impact those 37 individuals who are currently at the cap in one of those Bering Sea fisheries, Bering Sea crab stock fisheries. And yeah, I guess I'll leave it at that for now. And
thank you.
And get into it more during alternative 3. Thanks.
Thank you. And Ms. Gahn.
Thank you, Madam Chair. And my question's on Amendment 54, and if you can speak to when we'll start seeing the impacts of that amendment.
Through the chair, Ms. Goen, thank you for the question. So Amendment 54 was passed and implemented by was implemented in 2024. So depending on when individuals who are currently in the buyer pool decide to capitalize on that or respond to that change in the program, that may have already occurred and started to occur right after the implementation of that amendment, and that may continue to occur in the future. That has not yet been reflected in the data that's available in the most recent Crab Econ Safe, but in future years, we may start to see more transfers that have been spurred due to that decision calculus being altered by the fact that they no longer need to commit to long-term CR program participation.
Madam Chair, just sorry, it looks like we might have a technical issue with Zoom. Yeah.
Thank you, Mr. Pamplin. I think we'll work on that. We'll take a question from Ms. Goen first. So it might just be our screen.
Oh,
yeah. Okay.
Thank you. And just a clarification on your point there for Amendment 54, when you say that they're exempt from long-term participation, it means that they only have to participate every 3 years, not every year. Is that correct?
Yes, Ms. Goen, through the chair. So having been implemented in 2024, I believe it would begin to become constraining in 2027. Individuals would need to demonstrate participation for the first time since implementation of that amendment in either a CR program fishery or 30 days of participation in harvesting or tendering in another fishery off of Alaska by 2027 in order to get their IFQ issued again. And then in 2028, their QS would be revoked if they did not either do one of those two paths. Right, this slide gets into alternative 2 and the 2 modifications that are selected under alternative 2 to revise the transfer eligibility requirements. So each of these modifications would expand the pool of potential buyers. We'll do the modification in green first because that's the easy one. In green on that second bullet, that you'll see that under alternative 2, that time window to participate in one of the CR program fisheries would be increased from within the last year to the last 3 years. In blue, this is the modification that would allow individuals to use time tendering as part of that 150 days of sea time. Now, currently, only harvesting crew participation alone qualifies towards that days at sea requirement. And again, alternative 2 would modify that to include individual participation that an individual gets on a tender vessel, which stakeholders have noted is currently and commonly how fishermen begin participating in this fishery. So this slide, I'll take a moment here to highlight that there are 2 items for council consideration in that executive summary on pages detailed in pages 5 and 6. Both of those do pertain to that modification regarding harvesting. So on the left column, just to orient you on this real quick, the left column shows the current transfer requirements. So along with CR program participation, as mentioned earlier, an individual also needs to demonstrate 150 days of sea time as part of a harvesting crew. That harvesting crew participation, as underlined, can come from any U.S. commercial fishery, not only those in the waters off of Alaska. Comparatively, in that middle column, you'll see the current retention requirements. In the middle column, it states that 30 days of sea time as part of a harvesting or tendering crew needs to come from Alaska-specific harvesting or tendering experiences. So while you can use harvesting experience from any U.S. commercial fishery for the purposes of determining transfer eligibility, in order to continue retaining sea shares, you have to show that Alaska-specific harvesting or tendering participation. Now, as Ms. Goen pointed out earlier, I'll also note that that transfer requirement does have Alaska-specific provision baked in because individuals both need to meet that harvesting crew participation or harvesting crew days at sea requirement and the participation as crew in one of the CR program fisheries within the last year. So with that groundwork laid out, the right column shows the changes that would be implemented under Alternative 2. The language within the Council's motion for Alternative 2 asks to consider allowing Alaska-specific tendering experience to meet that 150-day requirement for transfer eligibility. That language mirrors what's in the retention language. So if it's adopted as is, the transfer requirement language would continue to allow harvesting experience to come from any U.S. commercial fishery, and it would be amended to allow tendering experience to be used, but only if it was Alaska-specific. So I've highlighted this here because the Council may wish to consider whether they'd prefer to keep the motion language as is, or whether they wish to expand the qualifying tendering experiences and allow tendering experience in support of any U.S. commercial fishery, as is the case for harvesting. So from research and stakeholder discussions, I haven't found evidence of any major tendering operations that occur outside of Alaska. However, this is not to say that they do not exist or will not exist in the future. So ultimately, this is a policy choice and a question of alignment and consistency. There are two paths, as I mentioned earlier. You could either align the tendering experiences that can be used across the retention and transfer requirements, either having tendering as both Alaska-specific in both of those requirements, or you can align the fisheries that can be used or the geography that can be used to prove eligibility for transfer requirements sorry, let me back up. Or you can have that aligned within the transfer requirements so that it can be harvesting or tendering crew, both being able to come from any U.S. commercial fishery. So the second piece for consideration, analysts assume that under Alternative 2, that tendering experience in eligible fisheries could be used alone or in combination with harvesting experience to meet that 150-day threshold. If only used alone, you'd have fewer individuals that could meet that modified requirement than would if they could be used in combination. And again, both of these considerations are highlighted here as something that the Council may wish to confirm or clarify within their rationale.
Thank you. And Ms. Goen?
Thank you, Madam Chair, and thank you for stepping through this. I know it's tricky to explain, so thank you for stepping through it. Could you also speak to, in the right-hand column here, how that language may compare to other IFQ fisheries in Alaska? I'm thinking halibut, sablefish, and I think the Council took recent action on that for these requirements.
Through the chair, thank you, Ms. Goen, for the question. So the recent Council action that is being considered to modify IFQ transfer eligibility requirements also uses that Alaska-specific tendering experience language. That could certainly be modified in the future. The Council has not taken final action on that yet, but the Council is currently considering that Alaska-specific tendering piece for IFQ. I will note that the Alaska-specific piece, that originally came from the development of Amendment 31 for crab, the CR program. there's a description of kind of the history on that, and let me navigate to where that is in the document. It's on page 23. So during the development of Amendment 31, which that was one of the first modifications to these transfer eligibility requirements taken by the council after the implementation of the CR program. That allowed initial recipients of C shares to use an alternative path in order to determine retention eligibility. And that alternative path was using 30 days of sea time as part of a harvesting crew in state or federal commercial fisheries in the EEZ off of Alaska. So it was Alaska specific. And within the council process, there was some public testimony that spoke to the fact that individuals had lost employment in the crab fisheries and instead found work in other Alaska fisheries instead. So that's just a little bit of background as to where that Alaska specific language came from, which was then left in place when the council took action on Amendment 54 and added tendering into the retention requirements, and then was also taken as part of this action to then allow tendering, Alaska-specific tendering in the transfer requirements, and then also Alaska-specific tendering in that IFQ action. So sorry for the long-winded history lesson there, but yes, the IFQ one is also Alaska-specific for that reason.
Thank you, Mr. Curlin.
Thanks, Madam Chair, and thanks, Ms. Holman. My understanding is that currently the transfer eligibility requirements for both programs are the same for halibut, sablefish, and for crab. NIMS has recommended that the council retain this or maintain this administrative consistency between the programs to consider the changes jointly. So is it fair to say that the council in this action should be thinking about the halibut, sablefish IFQ program as we finalize recommendations here?
Through the chair, Mr. Curlin, absolutely, yes. Although they are not both being taken up at this meeting, I don't have the 3-meeting outlook in front of me, but the council is considering, or it is scheduled to see the IFQ piece in 2026, and at that time could certainly consider, if they've modified the language for the purposes of this action to be harvesting or tendering it for any U.S. commercial fishery, they could certainly consider that same change for the purposes of the IFQ action as well. All right, so zooming out again to the expected impacts of both of the mechanisms under Alternative 2, that's the tendering piece and the expansion of the participation window. So both mechanisms may increase the opportunity and flexibility for active CR program fishermen and encourage new entrants relative to no action. That tendering mechanism would provide an alternative outlet for a CR program fishery crew member to achieve that 150-day threshold, which would be advantageous both when harvesting crew member opportunities are reduced, as we're seeing now, or in other situations where crew members have primarily or solely had tendering employment opportunities or experience. And again, crab industry participants have noted that that tendering experience has been a common way for CR program fishermen to begin working on a crab vessel. For the expanded CR program participation window, that would provide greater consistency between the transfer and retention requirements by both allowing them to have that 3-year window. And it would be advantageous when CR program fishery crew members are reduced, like for the tendering piece, and may also act as a buffer during short-term periods of consolidation. This slide summarizes some of the information on market impacts of Alternative 2 as provided in section 4.2.3. Both mechanisms provide additional avenues and opportunities for seashore markets to stabilize by increasing the pool of eligible buyers. Now, the increases to the buyer pool are difficult to quantify, and the magnitude of that increase depends on things like vessel counts, the retention and attrition rates of crew members, and the number of CR program fishery crew members who do not have that 150 days of harvesting experience, but would meet that threshold if tendering days at sea could also be included. Now, I will note here that eligible does not mean interested. Increasing the buyer pool may spur additional demand for C share, IFQ, and QS, but the magnitude of that is impacted by things like fishery conditions, particularly those of the BBR and BSS fisheries, individual decision-making, and the magnitude of that eligible buyer pool expansion. Also note that impacts from Amendment 54 will also play a role. By eliminating the CR program-specific requirements for retaining C shares, Amendment 54 is likely to increase demand for C share QS to some degree, though those impacts are also constrained by things like fishery conditions and individual decision-making. Any increased demand that results from Alternative 2 would increase the value of C shares. This may motivate or enable current C share QS holders to initiate the sale or transfer of their currently held quota shares, which would then create opportunities for new QS holders. Right, here I will turn to the other action alternative, Alternative 3. Under Alternative 3, C share use caps for 6 Bering Sea crab stocks could be increased to 5 to 10% individually. The BBR, BSS, EBT, and WBT fisheries are all subject to a 2% use cap for C shares, and the S&P and PIK fisheries are subject to a 4% C share use cap. Those variations in the caps were largely determined by variances in historical participation levels and fleet characteristics when the CR program was first established. Data suggests that many individuals are constrained by the current use caps. Some of the background on that was discussed in October and highlighted in section 3.4 of the document. And increasing use caps by any percent would provide more opportunities for current C share QS holders that are at the cap. It would allow individuals who have maxed out their investments to purchase additional C shares, and unlocking these potential buyers would likely provide opportunities for other C share QS holders who want to divest but can't currently find a buyer under the limited buyer pool. So these tables are one's from Chapter 3, one's from Chapter 4. I provided them both here to show some summary statistics on capped individuals and their holdings. The first table shows the holdings of individuals who are at or above, with holdings at or above that C share use cap by fishery. And I will note that this table in the PowerPoint does show updated data. The numbers in table 4-8 were stale in the analysis. I apologize for that. These numbers are the more current totals. So there are a total of 37 individuals with holdings at or above the use cap in the Bering Sea CR program fisheries. And in all but the SMB fishery, the holdings of those C share holders are between 20 and 30% of all C share QS that is issued in that fishery. The next table, 3-16, which is back in Chapter 3, shows the number of fisheries that these capped individuals own the maximum holdings in. So there's 17 individuals that are just capped out in one fishery, but you have 9 individuals that are capped out in 3 or more CR program fisheries. And this table reflects all CR program fisheries, not only the 6 fisheries that are being considered for changes in the C share use cap under this action.
Ms. Holman, we have a question for you before we move on. Mr. Williams.
Thank you, Madam Chair. I just wanted to follow up on the statement. It really goes to what Ms. Kimball's question was earlier. On the previous slide, you say data suggests that many individuals are constrained by the current use caps. And then your next slide, and maybe I'm just not interpreting it correctly. That doesn't look like many to me, but maybe I'm missing something. I get slow later in the morning.
Through the chair, Mr. Williams, no, that is a fair statement, and I will admit that many is subjective, and I may have written a subjective statement when I could have said several instead. Okay. You'll see a table on page 42, table 3-13, and I actually may have put that earlier in the slide under the Chapter 3 section about the percent of holders in each C share pool by fishery with holdings at or above that individual use cap. And for each of the fisheries that would be impacted by this action, between 12 and 17% of all of the C shareholders by fishery have holdings at or above the cap, except for S&B, which only has 3% of the QS holders at or above the cap. So I can't do math in my head, but I guess a fraction of that would be maybe like 1 in 7, 1 in 8 of the C shareholders by fishery. So maybe not many, but several. All right, the next couple slides are really data heavy, so I do apologize for just the giant tables with tiny numbers. These tables contain some summary statistics on the IFQ allocations under the current use caps and under alternative 3. So this is in sections 4.3.1 and 4.3.2 of the document. And those sections also include some more tables if you're interested in kind of getting into the weeds of the numbers. So table 4.3 shows the maximum IFQ allocation in pounds for a C shareholder under the current use caps. So I'm showing this to demonstrate and translate how changes in the QS use cap impact the maximum IFQ allocation in pounds. And you can see here that the maximum IFQ allocation in pounds fluctuates widely year by year based on the TAC. Table 4-4 shows the additional IFQ allocation in pounds for a C shareholder per 1% increase in the use cap. So just as an example, if you turn your attention to BBR, which is the first column of data, in 2024, an individual with holdings at the C share use cap in the BBR fishery would have been issued 1,386 pounds of IFQ. Meanwhile, back in 2007 was the peak year within this time frame. The individual would have been allocated 11,001 pounds of IFQ. For that individual, an additional 1% increase in the use cap would have been translated as an additional 5,500 pounds of IFQ back in 2007, but in 2024 would have only yielded an additional 693 pounds of IFQ. All right, so as I mentioned earlier, owning C shares can provide value to the C share QS holder through multiple channels, depending on how that owner decides to use the holdings. So in general, you have these 3 buckets of value: the ex-vessel value, the lease value, and the QS sale value. The tables on this slide show the value of the maximum C share holdings that are under the current use caps and the use caps considered by alternative 3. And this is a summary of table 4-7. And what I'll turn your attention to on these slides is that 10-year average piece. I find that helpful when looking at that data, and that is something that is not included on table 4-7 and just in these slides. So all values shown are the weighted average rounded to the nearest 1,000. So for BBR, so the average ex-vessel value of the raw crab pounds that are attributable to the IFQ pounds issued to QS holders with holdings at the 2% use cap, over the last 10 years, that weighted average was $40,000. If the cap was increased to 5%, then the average ex-vessel value of IFQ attributable to holdings at that 5% cap would have been $100,000, and under a 10% cap, that would increase to $200,000. For the lease value, under the current use cap, the 10-year average lease value of holdings at the cap was $26,000. Under a 5% cap, that would be $64,000, and under a 10% cap, that would be $128,000 a year that an individual could get from leasing C-share IFQ if their QS was at the cap. Finally, for the QS sale value, over the last 10 years, the weighted average QS sale value, if an individual sold holdings, divested their entire holdings of 2% cap, would be $199,000. Under a 5% cap, that would increase to nearly $500,000. Under a 10% cap, that would be around $1 million. You'll see the minimum and maximum years under the 10-year average in each table. I will not go through the rest of these tables, but I will note that the slide deck just shows BBR, BSS, and on the next slide, EBT and WBT. You won't see S&B or PIK because those have been closed during the last 10-year period, and therefore I can't accurately attribute any ex-vessel value, lease, or QS sale value to those fisheries.
I have a question for you, Ms. Holman. Mr. Pamplin.
Thank you, Madam Chair. Ms. Holman, apologize for interrupting your flow here. I just have a question about, so I'm sitting here looking at this table in particular and the purpose and need statement about increasing the number of new entrants into this. And when I think about increasing the cap, certainly understand how that helps existing cap holders to buy more. Understanding the analysis about people that might be on the sidelines right now wanting to enter if it's more lucrative to join in at a higher cap level, but also looking at some of these amounts that would be pretty restrictive of someone entering. So anyway, could you just speak to how the use cap you think also is consistent with increasing the number of new entrants, please?
Through the chair, thank you for the question, Mr. Pamplin. Alternative 3 would not change the number of individuals or size of the buyer pool. Only the existing eligible individuals would continue to be eligible if only Alternative 3 was selected. Alternative 3 may change the decision calculus of individuals who aren't investing at the current use cap because they don't see it as economically viable. But really, it is most likely to change the size of investment of individuals who are already at the cap and are unlocked under this alternative. So the buyer pool would only increase by allowing individuals who are at the cap to re-enter. So you're only seeing it increase by 37 individuals. And it does not, those individuals are already active in the CR program fishery because they need to be active in order to retain those C-share QS. It is not necessarily providing opportunities for new CR program participation or new C shareholders. These are existing C shareholders that would just be allowed to re-enter. Okay. So for the market impacts of Alternative 3, these are discussed in section 4.3.4 of the document. Alternative 3 would increase the buyer pool for C-share QS who have already invested up to the cap to re-enter the market. This may potentially increase demand by providing more opportunities for the current C shareholders who are capped that want to purchase additional quota shares by allowing them to re-enter that buyer pool, and may also increase for C share QS by making these individual investments more attractive to individuals who are already eligible relative to no action if these individuals don't see the scale of investment as economical given the current constraints on ownership. However, the magnitude of any market impacts are unknown and would be constrained by current fishery conditions. Under a low tax scenario, it's likely to continue to put downward pressure on any positive impacts that Alternative 3 would have on demand. Alternatively, C-share markets may stabilize under both Alternatives 1 and 3 if crab stocks improve, fisheries open, and tax provide more opportunity. Under Alternative 3, however, you'd see increased demand and value for C-shares, and by value I mean price for C-shares beyond what was seen in prior TAC years by easing regulatory restrictions on the buyer pool. So I'm back to more tables, I apologize. So table 4.9 on page 68 shows the minimum number of C shareholders by fishery that are allowed under Alternatives 1 and 3, as well as some information on the total number of C shareholders as of 2025-2026 crab year, and the C shareholders that are currently at the cap. So for all 4 fisheries with 2% use caps, the current number of C-share QS holders is approximately 100 C shareholders. I'll just kind of round those to the same number for the purposes of easy math, which is about double the minimum number of C shareholders that's that's allowed under that 2% use cap under alternative 1. Now that second column shows the number of capped individuals. So if the smaller use cap that's being considered under alternative 3, that 5% cap was implemented, up to 20 individuals could hold the maximum amount of QS in any of the fisheries considered. But I'm just highlighting those 4 fisheries with 2% use caps because that is those are the more active fisheries, and those have been open within the last 10 years. So for those 4 fisheries, if the CVC and CPC use cap was increased to 5%, up to 20 individuals could hold the maximum amount of QS. So in that scenario, all of the individuals with holdings currently at or above the use cap could re-enter the CVC or CPC QS market and proceed to increase their holdings up to the new use cap. This would, of course, be constrained by things like the amount of QS that's put up for sale. That consolidation certainly wouldn't occur immediately, but that is, in theory, the maximum amount of consolidation that could occur under a 5% cap. Now, under a 10% cap, in that case, only 10 CVC or CPC QS holders could own the maximum amount of QS. So for all 4 fisheries with current use caps at 2%, the number of cap sea share holders in the current crab year is currently above the minimum number of sea share holders that is allowed under a 10% cap. So depending on the interest, financial ability, and opportunities for those cap sea share QS holders to purchase additional QS under alternative 3, it is likely that consolidation would increase at an accelerated pace under a 10% use cap scenario versus a 5% use cap scenario. Thus, the proposed action could have mixed and uncertain impacts on entry opportunities in the future.
Question, Ms. Gone.
Thank you, Madam Chair. And I have to say, I was kind of surprised that under the current situation, status quo, alternative 1, that we don't have more people capped at the 2%. So, and I don't know if it's fair to ask you to think into the future, but if we did go to a higher cap, I mean, what do you see as the likelihood that, you know, say we went to a 5% cap, that we would get down to the just 20 people owning it?
Thank you for the question, Ms. Goen. In terms of likelihood, I certainly am hesitant to speak about likelihood. This slide just shows the theoretical potential. Mathematically, a 5% cap, there's 20 people that could own up to the 5% cap. That the pace in which consolidation would occur under alternative 3 and the range of options that are being considered under alternative 3 is something that I cannot accurately predict. I would turn your attention, however, to table 3-9 in the document, which gives us a great example of how consolidation has occurred under different scenarios, use cap scenarios in the CR program fisheries. You have 4 CR program fisheries with that 2% use cap under alternative 1, and that have had a 2% use cap unchanged for the 20-year duration of the CR program. So you have this great 20-year history of how consolidation has occurred. And I'm sorry, I don't have a slide on that, but that is on page 34. PAK and SMB have a 4% cap. So that's closest really to the range of use caps that are being considered under alternative 3. However, I will note that because of the long-term closures in the PIK fishery and the intermittent and long-term closures in the SMB fishery, they don't provide a great test case, but do show how some of the consolidation has occurred in those specific fisheries under that scenario. But yes, I would primarily turn your attention to that 3-9 table to see how that's occurred in the past, to maybe try to predict what may occur in the future. All right, table 4-10 on page 69. This shows the CVO and CPO versus the CVC and CPC use caps, all expressed as QS units. And for the sea-share use caps, that shows the cap that's currently implemented under alternative 1 and the use cap range that's being considered under alternative 3. So under both use caps use cap options considered under alternative 3 and for all of the fisheries that are considered for sea share use cap increases, the maximum QS units that can be held by sea share holders in any of these scenarios and for any of these fisheries is less than the maximum QS holders that can be held by CVO and CPO QS holders. And that again is because sea shares only account for 3% of the total IFQ issuance. And so, for example, in BBR, 1% of 388 million, which is 3.88 million, is still larger than 10% of the 3% CVC and CPC QS, which that would be 1.2 million.
Ms. Goen.
Thank you. And thank you for this table. It really shows the big difference between C shares versus A and B shares, which is also called CVO. Do you have a sense for how often or the number of C shareholders that then make that jump into, use that as a launching point to start buying A and B shares into that larger pool?
Through the chair, Ms. Goen, I don't have information or any data on that to show the number of C shareholders who also own A and B shares. I know that through the ROFO program in the past, when there's been A share transfers, a certain percentage of that is put up for sale for C share holders as the right of first offer. I am not certain as to when the last ROFO offer or ROFO transfer was last initiated, nor do I have information on the total amount of those that have occurred in the past. I apologize, I don't have more intel on that, but I know that in the past there have been opportunities for C shareholders to make that jump into A and B share holding. Right. This slide zooms back out to both alternatives being considered under this analysis, both action alternatives, that is. This discusses the management, monitoring, and enforcement considerations, which is in section 4.4 of the document. So if the transfer eligibility modification is adopted, then any individuals that are using tendering experience as part of their 150 day at sea eligibility requirement would need additional proof and verification beyond CFEC permit ownership in order to prove that they've actively participated in tendering for a commercial fishery off of Alaska in the last 3 years. The process that's used by RAM to verify eligibility for sea share QS relies on for verifying eligibility for the transfer and maintaining of sea share QS currently relies on legal attestation and acceptable evidence of active participation from the applicant. For example, a captain may sign off on the fact that a crew member participated in a CR program fishery during the eligibility window. The same process and methodology would be used to verify the eligibility of new sea share QS buyers if this modification were implemented. For alternative 3, the monitoring and enforcing of sea share QS use caps occurs when a QS transfer takes place. Because those use cap percentages are linked to the original QS units rather than the raw crab pounds, as the TAC fluctuates, QS holders are always going to be in compliance with the use caps without needing to divest. And under alternative 3, even if the QS use caps were modified, that same process and methodology that's already been established would be used. Right, this slide shows or just highlights quickly a table provided in the executive summary on page 7. This shows the just a summary of all 3 of the alternatives under consideration: the status quo alternative, alternative 1, alternative 2 regarding transfer eligibility, and regarding alternative 3 regarding use caps, and just some of the impacts on sea share provisions, markets, holders, and management. I won't go into all of these cells, but just highlight that this is available and may be helpful in decision making. Other content that may be helpful for consideration during the decision-making process include those specific items that were highlighted for council attention in the executive summary on pages 5 and 6, and as described in this presentation. There's also some information on MSA and FMP considerations included in Chapter 5 of the analysis. And that concludes my presentation. Thank you, Madam Chair.
Thank you, Ms. Holman. Ms. Gunn?
Thank you, Madam Chair, and thank you, Ms. Holman. I think on page 15 of the analysis, there's also a section where NIMS is suggesting some housekeeping measures for cooperative permits. I'm wondering if you could speak to that.
Through the chair, thank you, Ms. Goen. Yes, you will see in section 2.4 some other agency considerations. Though that highlights an expanded discussion paper that was prepared by NIMS in October 2025. Within that discussion paper, NIMS did remind the council of a previous recommendation to make a couple changes to the CR program that haven't yet been analyzed or implemented. And they noted that the council could consider adding one of those changes to this action. And specifically, that recommendation is removing unnecessary documentation for the application for annual crab harvesting cooperative IFQ permits. More information on that is included in pages 15 and 16 of the document. I don't know if I have NIMS folks available online to further answer that question, but I would just turn your attention to that section for more information on that recommendation. Oh, yeah, I see Alicia Miller is online. Perhaps I could call on Alicia for additional information on that recommendation. Oh, Alicia, you can unmute if you'd like.
We can't quite hear you yet, Alicia.
I'm having technical difficulties.
We can see that you're unmuted, but can't hear you. Are there any technical difficulties? Okay, so maybe we can come back after lunch and see if she can answer that before we take up our AP report, if that's okay. Great. Okay, thank you. Are there any additional questions at this point? Okay. All right, seeing none, this brings us to a good point to break for lunch. Let's come back at 1:30. We'll circle back to that question and then take the AP report. At the conclusion of the AP report, we will begin public testimony. So just for members of the public wishing to testify, please do follow the timing of the AP report and sign up before the end to make sure you're on the list. So we'll see you back at 1:30. Thanks.
Testing, can you hear me? Testing, testing. This is Alicia. Can you hear me?
Can you go ahead and take a try again?
Hello, this is Alicia. Can you hear me?
Yeah, we can hear you. We're turning up the volume here.
Okay, thank you.
Yeah, I think that's good.
Council members, please come to order. So we're on our C2 agenda item. I think we were going to follow up with Alicia Miller online and Ms. Holman. I think we might have a couple additional questions for you if you wouldn't mind coming to the table. But if Alicia's online, maybe we could circle back. Let us know if you need us to repeat well, actually, we should repeat the question, please. Ms. Goen. Thank you.
Thank you, Madam Chair, and thank you, Ms. Miller, for being online to answer this question. My question was around page 15 in the analysis where NMFS is recommending removing paperwork burden for co-op permits for existing co-ops. New or changes to co-ops would still need to submit that paperwork. But I just want to make sure I've got that right.
Through the chair, Ms. Goen, just checking, can you hear me okay?
Yes, I think everyone has you. You're a little faint. But
Okay, yes, Ms. Goen, you do have that correct. We're just looking for concurrence as to whether or not the council wants us to go forward with those potential changes, and we would include analysis of that in the C-share action with the proposed rule.
Thank you, Ms. Miller. And Ms. Goen.
And a follow-up, and this one I think is for Ms. Holman. If you could clarify when we were talking about the tendering provisions and whether they applied to Alaska waters or any U.S. commercial fishery, which way would be more consistent with existing regulations?
Through the chair, Ms. Gohan, allowing tendering to come from any U.S. commercial fishery would be more aligned with current regulations. You have within the transfer provisions of both sea shares and the IFQ for halibut and sablefish. For both of those, harvesting experience can come from any U.S. commercial fishery. Allowing tendering experience to also come from any U.S. commercial fishery would align that geographical experience and make that more consistent within those transfer regulations.
Thank you. Are there any other questions for Ms. Holman before we go to the AP report? Thank you. Okay, so we're ready to move on to our AP reports. And just a reminder to the public, anyone wishing to testify on C2, please do sign up before the end of the report. Thanks.
Good afternoon, Madam Chair, council members. I'm Heather Mann. I'm a vice chair on the advisory panel, and I'll provide you with the C2 motion. The AP recommends council take final action on the BSAI Crab Sea Shares agenda item with both alternatives 2 and 3 as the final recommendation. Specifically, under alternative 3, the AP recommends the BBR, BSS, EBT, and WBT sea shares use caps be raised to 3.5%, while SMB and PIK sea share use caps remain unchanged at 4%. That motion passed unanimously, and I'd be happy to try and answer any questions.
Thank you for the reports. Are there any questions? Yes, Ms. Goen.
Thank you, Madam Chair, and thank you, Ms. Mann, for the report. I'm curious if you can explain a little bit around the 0.5%. Why 3.5% for the use cap instead of just 3 or 4 to keep the math more simple?
Through the chair, Ms. Goen, thank you for that question. We did not have a discussion around the ease of a 0.5% versus 1%, but the 3.5% came directly out of the feedback that was received in the anonymous survey that went out as a compromise. So literally like the middle of the road, but we did not, to my recollection, discuss the ease of a 0.5% compared to 1% in terms of the math.
Thanks for that. And just to clarify for anyone listening online, I think the anonymous poll you're referencing is in the, it's going to come up in public testimony. It was in public testimony at the AP from Alaska Bering Sea Crabbers.
Yes, thanks for that. And I'll just add there's more description about that in the rationale to the AP report as well for people that are interested.
Thank you. Yes, Mr. Ritchie.
Thank you. Thank you for the report. My question was actually about that poll as well, and I wasn't sure if it was going to be brought up. So I'm going to, okay, I was looking for the nod and I got the nod back there. Okay, thank you.
Okay, I'm not seeing any other questions. Thank you for the report.
Thank you.
Okay, so now we're ready to move on to public testimony on C2. We have 5 people signed up to testify. Just a reminder to the public, individuals and companies will have 3 minutes to testify, and organizations and associations 6 minutes. So we'll begin with Cory Lescher, followed by Oystein Lone.
Good afternoon, Madam Chair and members of the council. Once again, for the record, I'm Cory Lescher with Alaska Bering Sea Crabbers. ABSC is a trade association representing the majority of independent crab harvesters who commercially fish for king, snow, and bear-dye crab with pot gear in the Bering Sea and Aleutian Island crab rationalization program. Again, thanks for the opportunity to let me testify in front of you today. We'd like to acknowledge all of the work by the authors put into the analysis and the presentation and answering of very tough questions that we just heard from the report prior to lunch. Alaska Bering Sea Crabbers supports Alternative 2 to increase flexibility in the eligibility requirements for sea shares, and Alternative 3 to increase the use caps to 5%. Expanding eligibility to include tendering experience and extending the participation window from 1 year to 3 years are practical adjustments that in part address some of the challenges that we've seen with low TAC years and fewer vessels and opportunities for fishermen to participate in the crab fisheries. We believe it will allow more working fishermen to be eligible buyers. Likewise, increasing sea share use caps to 5% could encourage further investment and entry into the fisheries. Together, these changes will increase opportunity, increase flexibility, and ensure that sea shares remain a pathway for active fishermen, crew, and new entrants into the BSAI crab fisheries. For this council's awareness, Alaska Bering Sea Crabbers ran an anonymous poll prior to this meeting to the portion of our membership that's made up of quota shareholders, vessel owners, skippers, and crew to try to reach that audience to get feedback on the proposed use caps before the council considers final action at this meeting. So the poll simply asked whether they would support status quo, so no change in the use caps, or a medium increase up to 5% for each crab stock, a large increase up to 10% per crab stock, or an other option. I will note that, as you might expect, when polling independent fishermen, there was a wide range of responses. But that being said, just to report to you guys here, 38% of the respondents were supportive of status quo. 38% of the respondents were supportive of a medium increase up to 5%. And the remaining 24% of the respondents were in favor of a large increase up to 10%. There were no respondents that selected the other option. These results were then presented to the ABSC Board of Directors, which deliberated and ended up landing on an agreement to support Alternative 3 to increase the use caps to 5%. Madam Chair, that's all I have. I'd be happy to try to answer any questions. Thank you.
Thank you very much for your testimony. Are there any questions? Yes, Ms. Vanderhoven.
Thank you, Madam Chair. Thank you, Mr. Lescher. This is the first I'm hearing about your polls. So you mentioned percentages. What was the size of the pool of respondents? So 38%, 38%, and 24% of what number?
Through the chair, Ms. Vanderhoven, I believe we had 21 responses.
Yes, second question.
Yeah, thank you. As a follow-up to that, so we had the 16 in the table who were at the cap or over the cap. You had 21. Do you know what percentage or how many of your 21 respondents were part of the pool that's at or above the cap?
Through the chair, Ms. Vanderhoven, I believe it was anonymous. I'd have to go back and look if there was any comments, if folks were able to select whether they were capped out or how much they own, but I don't know off the top of my head, sorry.
Mr. Williams.
Thank you, Madam Chair. After your poll, your board, did you guys have any discussions about concerns about consolidation into the future, too much consolidation? One of the reasons you deal with caps the way we do is to avoid that. But was there any discussions around the table concerned about that into the future?
Through the chair, Mr. Williams, yes, my understanding is that there was, and some of that was captured in the poll itself. So as I noted, 38% of the respondents were in support of maintaining status quo, and in rationale provided that they were able to provide for their responses in the poll. There was some concern over consolidation, and yeah, I guess I'll leave it at that.
Thank you. And Mr. Pamplin.
Thanks, Madam Chair. Appreciate your comments, Mr. Lescher. Just a quick clarification. Were you saying increase the use caps to 5% or by 5%? So would 2% go to 5% or would 2% go to 7%? Thanks.
Through the chair, yeah, thank you for the opportunity to clarify, Mr. Pamplin. I tried to word that in my testimony the best I could, and I think that left plenty of room for confusion. Increasing up to 5%, so not by 5%, but up to 5%. And I think the language was meant to allow for flexibility in whatever percentage it would be, but up to no more than 5%.
Yes. And Mr. Sakata.
Yes, thank you for your testimony. When you say 21 responses, what was the total number of surveys that did go out? Yeah, let me just ask that first. Roughly is fine.
Through the chair, Mr. Sakata, I'm not sure what percentage of our membership this poll went out to. I don't think I have that in front of me.
Maybe clarifying then. Members are companies. These are crew position surveys. So could one member have provided 10 of the 21 responses? I mean, yeah, member versus like multiple surveys went out to a single member because their crew is multiple.
Through the chair, Mr. Sakata, I do know that our poll went to quota share holders, vessel owners, skippers, and crew. Those who might be, per se, a quota shareholder and a vessel owner and a skipper. I'm not sure if they had the opportunity to submit multiple responses. I don't think that's how this survey platform works, but I'm not sure. I'm getting the nod that I think one response per person.
Okay, thank you.
Yes, Ms. Kimball.
Thank you for your testimony, Mr. Lescher. Of the issues that you noted prior to getting to your positions, like how does that relate to increasing the use cap? Like what problems are we addressing by increasing the use cap?
Through the chair, Ms. Kimball, if I'm understanding your question correctly, I think there's interest in building in flexibility to C shares, and that's part of this action, but also allowing for further investment for folks that are capped out, wanting to invest into their fishery more than they already are, and so my understanding, taking the stance that the board landed on, was allowing that opportunity, but beyond that, I'm not sure I'm able to answer the question.
Okay, I'm not seeing any further questions. Appreciate your time. Okay, Oystein Lone is next, followed by Canyon Willis, and both of those members are joining us remotely.
Yeah, good afternoon, members of the council. My name is Oystein Lone. I am a crab captain and sea share holder. I got a little bit of tidbit of sea share back in the day when it got allocated, and I've since maxed myself out. I'm one of the 16 that has bought everything up they can. And this is a great program, and it's provided a nice pathway for me to invest and grow into the business. I now have 2 crab vessels and a couple of young captains working for me, and hoping they can start buying into this program. So my position is on this is no action on anything. Leave the Sea Share program alone. This was meant for active participants, and making any changes could undermine and destroy its original intent. We must consider the future. We are in some hard times right now. We're all seeing it in crab, and but we're seeing a lot of stocks recuperating out here and expecting quotas to go up here in the next few years. So I think this problem is going to be solved when that happens. As participants age out in this fishery, they need to sell their shares. And that is my plan here in the next few years. I'm going to be selling my C shares and just divesting into more A shares. One thing it ties in here, but it doesn't, but is the ROFO program. And that enables us 16 that have invested and bought as much as we can. It would create a bridge for us from C shares to buy A shares. And we need to get that program back on track. It's suspended right now due to funding, but I think we can find some money somewhere to get that up and running again. This would create a bridge for us C share guys that are maxed out to continue, and leave the pool of C shares for the new guys that are coming into this business. We're having a lot of new guys running boats, a lot of new crew members coming out here, and we have to leave the opportunity for these guys, for the next generation. I'm very concerned if we do start making changes to this and turn it into a mailbox fishery, it's going to ruin the whole intent of the program. And this is a very special program. I think probably the only one that we have in our fisheries, and we have to take care of it. So that's all I have, and I'll take questions.
Thank you very much for your testimony. Let's see if there are any questions. Yes, Ms. Goen.
Thank you, Madam Chair, and thank you, Oystein, for your testimony. I heard you say no action on anything, so I'm taking that to be alternative 2 and alternative 3. And my question for you is under alternative 4. The changes we're considering would increase flexibility, particularly in times of low crab quota, to help, for example, time tendering, which we know is an entryway for many crab fishermen to become crab fishermen. They start out tendering, so to allow that time to count towards the 150 days. But I'm hearing you say you don't support that. I'm wondering if you can explain why.
Well, I was listening to the discussion there earlier. I'm a little concerned that if we open it up to tendering and we have people in tendering buying into the business and buying quotas, if that would hurt the active crab fishermen that are on the grounds. Now, if they have to stay active somehow, I would say that would be fine. But we don't want to take this away from the crab fishermen and the upcoming deckhands and captains that are coming into the business. It needs to be for this program.
Thank you. Are there any further questions? Thank you for your testimony.
Thank you.
Our next testifier is Canyon Willis, followed by Tim Willis. Is Canyon online?
Yeah, can you hear me?
Yes, good afternoon.
Hey, how's it going? I'm currently actually hauling a string fishing West Barrett out here up near St. George. And I am been fishing crab for 10 years now. I've worked my way from the bottom, and just in the last 2 seasons, become a captain here. And I am very interested in buying into the industry. And right now, this program, as it sits, is a great opportunity for guys like myself. And I've also spoken to a number of other younger captains and guys that I think will be captains in the next few years as this next generation or the older generation ages out. The next generation starts to take over. We got a lot of old captains, a lot of old owners that are going to be dying and phasing out of this industry. And if we increase this cap limit, it essentially will put me 17th in line to purchase C shares. So my stance on this is no action on all of it, including the tendering. I think there's plenty of opportunity for guys to stay current in the crab industry. And I don't think tendering should have any part of that. So that's my opinion. I'll take questions.
Thank you for your testimony. I'll see if there are any questions for you. I'm not seeing any. Thank you for joining us from on the water, and safe fishing to you.
Yep, thank you.
Thanks. So Tim Willis is next, followed by Craig Lowenberg. Tim, can you unmute yourself?
How about now? Can you
Yes.
hear me okay?
We can.
Okay. Great. Yeah, thanks for the opportunity to speak today. As you can imagine, I'm Canyon's father. And one of the reasons I'm speaking today is to support this younger generation. I've been around long enough to see the inception of the rationalization program. I was denied C shares on a technicality myself, and looked a couple different times over the years at trying to get in, and it was always a challenge. The numbers never quite made sense for me. I ended up investing in other fisheries and not becoming a quota shareholder myself, but I would like to keep that option open for the younger generation. When the rationalization program first started, we were told all kinds of things about how the C shares were going to allow us to have a stake in the fishery, how we were going to have great financing packages that were going to allow the working fishermen to buy into the fishery and have a stake in the fishery. And, a lot of that went right out the window. A lot of those things didn't materialize. And we've had just a massive consolidation in the fishery, and economic circumstances definitely contributed to some of that. But right now, the C share program is really the only program that's keeping the door open for guys to get a stake in the fishery, without coming in with mass amounts of capital. It's still not always sure that it makes financial sense either. Oystein's done well with it, sounds like, and I'm sure there's a lot of other people that have done well with it. But any more consolidation of the fishery just doesn't make sense at all. This is our last ability to keep some of the stake with the people that are actually fishing the quota. We're losing that ability for our active fishermen. And I think that anything we do to compromise that even has the potential for more consolidation is absolutely a failure on the part of the stewards of this fishery in moving it forward into the next generations. I definitely I'm against all parts of the proposal. I think there's plenty of active positions in the fisheries. Just try hiring a crew right now. It's a challenge. Just about anybody can get a job if they really want it. So I don't think there's any need to add tendering in there. I don't believe there's any need to up the percentages that are able to be held by C shareholders. I think that the bigger problem and the thing that the proposals maybe should be working on is trying to find other ways to convert some of the other shares into shares that are held by active fishermen. Oystein speaks of the right of first refusal, which is a great program, creating some financing for purchase of A shares, or trying, if you really see shares as the way to do it, then let's figure out how to move some of those shares into C shares. Let's make that. We were promised a lot more than 3% for a long time before the final numbers came out. When that final rationalization package came out, there was nothing left. We just got a pittance. And that's just contributed to more and more consolidation of the fisheries. So I am against all parts of the proposal, and I hope that the council does the right thing and does everything they can to allow future generations into this fishery and allowing them to become stakeholders. Thank you.
Thank you for your testimony, Mr. Willis. I'll see if there are any questions. Seeing none, thank you for your time.
Thank you.
So Craig Lowenberg is our last testifier. Thank you, Mr. Lowenberg. So that concludes our public testimony on C2. So let's take a 10-minute stand down and come back and see if the council would like to take action on C2. We'll see you back here at 2:10. Thank you. We just need a couple more minutes. We're having a little technical difficulty here. Welcome back, everyone. So we have finished our presentation and public testimony on C2. Just a notice to the public after we take action or have a discussion on C2, we'll be breaking for the day. We have a scheduled executive session at 3 p.m. So would ask members of the public to clear from the room before 3 p.m. But I'll ask council members if they'd like to take action on C2. Begin that discussion. Ms. Goen, thank you.
Thank you. I have a motion to share if staff will put it up. Thank you. So the motion reads, the council adopts the following alternative for final action. Alternative 2, revise eligibility requirements to purchase, receive C shares by transfer. Allow time tendering in any U.S. commercial fishery to count toward the 150-day eligibility requirement and increase the time to 3 years to participate in a crab rationalization fishery trip. In addition, the council recommends National Marine Fisheries Service include in this action the change described in section 2.4 of the analysis to remove unnecessary documentation for the application for annual crab harvesting cooperative IFQ permits for existing cooperatives and only require it for new cooperatives or changes to existing cooperatives. And with a second, I'll speak to it.
Thank you for the second, Mr. Pamplin. Ms. Gahn.
Thank you. To start, I want to thank council staff for their work on this analysis and for the refinements since the initial review analysis. I also want to acknowledge the variety of perspectives we heard in public testimony, with the majority of comment varying between status quo or implementing the increased flexibility for transfers and capping use caps at 5%. And I especially appreciate the active fishermen calling in from the grounds and Alaska Bering Sea crabbers for polling their harvesters, including captains and crew. This motion reflects just moving forward with Alternative 2 to increase flexibility and opportunity for new entrants in the Bering Sea and Aleutian Islands crab rationalization program, consistent with the purpose and need for action. In addition, it more closely mirrors recent regulations implemented last year for maintaining sea shares by allowing tendering to count, creating consistency and simplifying regulations, and is consistent with the new executive order on seafood competitiveness by increasing opportunity for fishermen. Under Alternative 2, both measures, allowing tendering to count toward the 150 days and increasing the window to participate in a crab rationalization fishery from 1 to 3 years, should expand the pool of individuals who are eligible to receive sea share, quota share by transfer. This alternative maintains the intent of the program to be for active crab fishermen with the requirement that they would have to participate in a crab fishery. Table 3-5 in the analysis shows the decline in crew opportunities on crab trips in recent years, declining between 33 and 25% through 2022 due to the Bristol Bay Red King crab fisheries being closed or low harvest levels. It would likely be a steeper decline if more recent data, including the Bering Sea snow crab fishery closure, were included. This action addresses the challenge of less vessels fishing and less crew opportunity by extending the active participation requirement from 1 to 3 years. Notably, this motion clarifies that tendering from any U.S. commercial fishery would count toward the 150 days. This was changed from just being Alaska waters to all U.S. commercial fisheries to increase the pool of potential buyers and to align the requirement with similar existing regulations, as we heard from staff today. This would streamline and simplify regulations and be more inclusive. This motion includes a recommendation from National Marine Fisheries Service in the analysis on page 15 and consistent with the Council's motion on the executive order last June and October. It would remove unnecessary documentation for the application for annual crab harvesting cooperative IFQ permits. The proposed change in this motion would remove the need to annually submit paper copies of business documents for existing cooperatives. The requirement to submit paper copies would remain for new cooperatives or any existing cooperatives that experienced a change. I did not include Alternative 3 in this motion to increase use caps. Thus, sea share use caps would remain status quo. As we heard during the presentation, a previous similar action through Amendment 54 on maintaining sea shares is still in the process of full implementation, which will fully play out by 2028 when sea shares may first be revoked for those that didn't comply with the active participation requirements. My thinking is that we have several moving parts with this action and the related Amendment 54 action, both liberalizing the requirements for transferring and maintaining sea shares. Both actions should increase opportunity for active fishermen to own sea shares, and I'd like to see how these two changes influence the pool of active fishermen before adding another layer to increase use caps that has the potential to consolidate the number of sea shareholders to some degree, although I don't think they're going to be hitting that maximum consolidation outlined in the document. I just don't think that's likely to happen because it hasn't happened under the current caps. In addition, not even half the pool of sea shareholders are capped at the current levels, so there's still room for further movement in that pool. Increases to sea share use caps could be considered again at some point after 2028 or during the next program review cycle, which is around 2030 or 2031. I will say I came to this meeting leaning towards recommending a sea share use cap increase of 4 to 5%, which aligns with Alaska Bering Sea crabbers' recommendation based on their poll of crab harvesters. However, several factors influenced me shifting my position. listening to the AP on this agenda item, gathering more information, including from quota brokers, analysts, and stakeholders, and hearing public testimony today. Plus, as I consider Alaska Bering Sea Crabbers poll responses, there was equal support between 5% and status quo. Both of them had 8 votes, where a 10% increase only had 5 votes. I decided to be cautious and approach alternative 2 and alternative 3 in a stepwise fashion, waiting to see how increasing flexibility in the requirements to transfer and buy C shares and maintain C shares plays out before considering increasing use caps. This motion complies with the Magnuson-Stevens Act national standards and other applicable law as outlined in Section 5 of the analysis. I highlight that National Standard 4 and 6 are particularly relevant. National Standard 4 states that the action will not discriminate between different states. This action increases flexibility in adding time tendering in any U.S. commercial fishery to count, and therefore does not discriminate between states. I'll note I didn't see mention of alternative 2 under National Standard 4 in the analysis, and I encourage the analyst to update that in the final documents for the regulatory package. For National Standard 6 on allowing contingencies and variations, that is part of the heart of this action to add flexibility and opportunity for the program to address contingencies like those seen recently with low harvest levels and limited opportunity to participate in a crab trip. As noted in the analysis, this action will not affect production from the fisheries, and consumer and producer surpluses are not expected to be impacted. Therefore, this action is not expected to affect the net benefits to the nation. Finally, I want to flag, like I did under comments for the arbitration agenda item, that there are ideas that we might want to address further at some point, including increasing C share use caps, as I just mentioned, and also how to help active fishermen buy A and B shares, also called CVO, through programs like ROFO and financing. We heard that in public testimony today, and I think it's an important piece that we need to be considering, how to help our active fishermen in this fishery. And with that, I'm happy to take any questions.
Thank you, Ms. Goen. Are there any questions? Seeing none. Ms. Baker.
Thank you, Madam Chair, and thank you, Ms. Goen, for the motion. I just want to really clarify, I think you explained this pretty clearly, but your proposed alternative 2 here is actually a revision to what we're looking at in the document in terms of you're replacing the requirement for time and tendering in an Alaska commercial fishery by any U.S. commercial fishery. So just want to make sure I understand. It's different than the alternatives we're looking at in the analysis.
Through the chair, thank you for the question. I think it's within the analysis, but it is different than what was outlined under the alternative, if that makes sense. And I'm happy to speak more to why I increased and liberalized that if needed.
Yes, Ms. Watson.
Through the chair, thank you. Ms. Goen, I have hopefully a couple questions that won't confuse everyone. I apologize. I just want to make sure that we have clarity on, you spoke to alternative 2 would create consistency with the recent changes under Amendment 54, which changed the regulations pertaining to the issuance of IFQ and the retention of quota share. That action allowed for individuals to use tendering, I believe. So that's the consistency we're speaking of, not the transfer requirements apply to, and this speaks to, I think, a bit of what Ms. Baker was touching on. The transfer requirements speak to participation in harvesting or tendering in any U.S. commercial fishery versus for the issuance of IFQ and the retention of quota share, participation in either harvesting or tendering in state of Alaska or federal fisheries off Alaska.
I will try not to make this any more confusing than it already is. It's consistent with Amendment 54 because it includes tendering in the eligibility, and it includes that expansion from 1 to 3 years for active crab participation. For the tendering piece, though, it is different than maintaining sea shares in Amendment 54 because it would include any U.S. commercial fishery, not just Alaska waters. So the requirements to maintain sea shares are more restrictive. You have to have been participating just in Alaska waters.
Thank you. Any other questions? Any comments? Any amendments first? Okay, any comments? Yes, Ms. Baker.
Thank you, Madam Chair. Thank you, Ms. Goen, for the motion. And I really appreciate your speaking to it. I think I also thought the analysis did a really nice job of laying out the issues involved in here, and very much appreciated the testimony that we received on, again, different perspectives on this issue. And I myself was struggling reconciling alternative 3 in the analysis to potentially increase the use cap with some of the other factors that you explained. And I think this is a really nice, I'm very comfortable with this approach, and I appreciate the motion, and I will be supporting it.
Thank you. Mr. Mueller.
Yeah, thank you, Madam Chair, and thank you for the motion. I too will be supporting the motion. I think we heard some pretty compelling public testimony relative to, a broader or a addressing the use caps in this motion would have likely not gotten my support. So thank you, Ms. Goen, for keeping that out of the motion. I think the public testimony that really touched me was the possibility of the degradation of the intent behind this program, and to hear that from active fishermen that potentially would benefit from an increase in the use cap was pretty compelling to me. So thank you again, Ms. Goen, for the motion, and I'll be supporting it.
Any further comments? Yep. We have any amendment? Yes, we're gonna just stand down one moment. We need a deeming amendment. Thank you. Ms. Baker.
Thank you, Madam Chair. Apologies for my technical difficulties. I have the amendment, the standard deeming amendment that I would like to offer once it's posted. The council deems proposed regulations that clearly and directly flow from the provisions of this motion to be necessary and appropriate in accordance with Section 303C. The council authorizes the executive director and the chair to review the draft proposed regulations when provided by NIMS to ensure that the proposed regulations to be submitted to the secretary under Section 303C are consistent with these instructions.
Thank you for the second, Ms. Vanderhoven. And Ms. Baker, would you like to speak to it?
Thank you, Madam Chair. As per usual, as Mr. Pamplin noted earlier, the council has 2 deeming options. I am choosing the standard second option, and I think it's appropriate in this case, for the executive director and the chair to review the draft proposed regulations, and that's what I'm proposing.
Thank you. Any questions on the deeming amendment? Any comments? And any opposition? Okay, that amendment passes without opposition. So we have the amended main motion. Any last comments? Okay, seeing none, thank you for all of your efforts on this, Ms. Goen. So we are needing a roll call vote on this. Ms. Evans?
Madam Chair, this is on final action for C2 Crab Sea Shares to adopt alternative 2 as revised on screen, and adding removal of unnecessary documentation element to that action. Ms. Goen.
Yes.
Ms. Kimball,
Yes.
Mr. Kurland,
Yes.
Mr. Mahler,
Yes.
Mr. Pamplin,
Yes.
Mr. Ritchie,
Yes.
Mr. Sukata,
Yes.
Ms. Vanderhoven. Yes. Mr. Williams,
Yes.
Ms. Baker,
Yes.
Mr. Abnika.
Yes.
The motion passes unanimously. 11-0.
Thank you. Thank you, everyone. Any further action on C2? Seeing none, so we're going to break for the day. I'll ask council members to come back promptly at 3 p.m., maybe a minute before, so we can start executive session. And again, members of the public, please clear the room by then. We will start our morning at 8 a.m. and begin with our SSC report, and then we will go into C4. Okay, so thank you, everyone, and have a good evening.